morning, everyone. I'll call the meeting to order. Is it, well, before we get started, is there any substitutions? Very good. Is it the pleasure of the committee to take into consideration Bill number 19, Fiduciaries Access to Digital Assets Act? All those in favour, please say yea. Yea. Against, nay. Carried. Minister, do you have any opening comments or introduce your staff?
I can make a couple of comments. If there was ever a bill that the name accurately described the bill, this is it. Fiduciary access to digital assets. A fiduciary, by definition, is a person who occupies a legal position whereby they have charge over a person's property and affairs. That can occur when a person dies, a person who becomes an executor of their estate, or an administrator if the person happens to be intestate. It could include a person who's appointed under a committee for an Infirmed Person Act, or it could include a power of attorney. So a fiduciary is a person who is a representative of another person or their estate and has all the powers of that person. It is a position of trust, but nonetheless, it is a position that is a necessary occurring thing. So that's the fiduciary. Well, access, that's pretty clear. It's the person who has a position of trust, needs to access something. And what is that? Digital assets. Now, far be it from me to be the member of this House who is the poster boy on digital anything. I'm coming along, but perhaps I don't go to the leading edge of this. But here's what I do know: that a digital asset is an asset which permeates our society. It's everywhere now, and we see them in the form of email accounts, virtual currency, whatever that is. A person no longer talks about a family album. They talk about the digital pictures that are online. We don't talk about someone's library. We talk about all the e-books that they have. We don't talk about all the records and music and tapes and DVD, CDs and everything. We talk about the online digital assets. We have things like loyalty points, frequent flyer points. People build up assets like this digitally, which are worth a fair bit of money. The value of some of these loyalty programs, it is in the millions and millions and millions of dollars over all the people that are members. So the law in its present form doesn't adequately deal with how fiduciaries gain access to these kind of digital assets. And it doesn't make clear exactly what the duty of a fiduciary is with respect to these digital assets. I mean, nobody gets a bank statement anymore. Everything is digital. You put in your username, your password, the bank's web page, log in. It's all there. I mean, even mailboxes now are becoming somewhat obsolete because we do so much digitally. Everything from your power bill to your phone bill to your pay. So this is the world that we live in now, and that is a good and positive thing. So this act brings fiduciaries into the world that we live in today, and so that they can have access to these assets. These assets have value. They have either monetary value, they have personal value, they have family value, things of that nature, and this Act does that. This is common in several jurisdictions. Legislation similar to this is being looked at, if not implemented, in all 10 provinces, and I think 47 of the 50 states of the United States are moving towards enabling fiduciaries to have access to these type of digital assets. So that's a little background to the Act here. There's lots of information here on Uniform Commercial Code and work that's done in other jurisdictions. I don't think that you could find a political issue in this Act if you tried. It's just legislation that I believe is proper, it's good, it's timely, as we are a month away from 2023, so we should be embracing legislation such as this. So I hope that gives my friends across the floor a little bit of background as to what this bill proposes to do, and we'll now go to questions.
Thank you very much. Member from Moncton Centre.
Yes, thank you, Mr. Chair, and thank you to the Minister for your opening comments. It addresses a lot of the issues that we have outlined in our questions, and so you had indicated that the fiduciary in this Act, that it would be different scenarios on death, an executor of an estate, or if it's a person who's incapacitated, be appointed an administrator. It could be under the Infirm Persons Act, or granted under a power of attorney. So I don't know if this covers everything, but the question I had was with respect to the particular fiduciaries to whom this Act applies. Are there any other scenarios not covered in your preamble that I just went over?
I think, member, that you've got it pretty well down, and I think the specifics of it, if you go to Section 1 of the Act, the definitions, fiduciary is a specifically defined term, and it's defined, and it lists personal representative, power of attorney, deceased, trustee, whatever, and all those things are specifically listed. So given, as you I'm sure well know, any act or statute operates within the four corners of that act. So a fiduciary, if you're not included in the definitions, then it would not apply to you. So that's the definition. A, B, C, D, and E. I won't read them through. They're there, but certainly you hit the nail right on the head with respect to the concerns, and I believe that those questions are very clearly answered in the definition section.
So with respect to a will or a power of attorney, for example, will there need to be specific provisions laid out in those documents addressing this issue, or does this Act extend automatically to an executor of an estate, or for a power of attorney, would this power follow without specifically referencing digital assets or being a fiduciary for that matter?
Again, in the definition, the Act will apply by default to every single item that's listed in the Act. Now, if you're a client and you're doing their will and you want to specifically refer to digital assets, I mean, I leave my ABC company frequent flyer points to my son or whatever you want to do, that you can deal with it easily enough. But by default, it is covered under the Act with the power of the fiduciary.
And so in your preamble, you had indicated that you're not the poster boy for digital assets by any means, but I'm sure your staff, your department's been consulted, or you've had consultations on this. So what kind of consultations have you had to inform you on bringing this legislation forward? I know in your second reading statement you talk about the Uniform Law Conference, and you talk about the different provinces adopting legislation. So could you indicate what kind of consultations you had to bring this legislation forward?
Yeah, we have done consultation with the usual suspects, I suppose. The Office of the Attorney General deals with the Uniform Law Conference of Canada. We established a working committee comprised of legal practitioners, scholars, academics, government lawyers, law societies, and things of that nature to review this. The law reform notes to all this, input was requested and it was received. And positively, I may say that this legislation would be very useful. Many groups, such as the Law Society, the Society of Estate and Trust Practitioners, have also identified their positive feedback towards this, that it is good, necessary legislation to access these. The public trustee as well was consulted. And again, the consultation was supportive of the legislation. So I suppose all the people that you would normally, and all the organizations that you would normally do have been consulted. The result has been universally positive. I mean, there isn't any reason not to do this. I mean, for what reason would there be to prevent a fiduciary from accessing a digital asset? There isn't. If you look at it in the reverse, why would you not? They have, by law, they have access to real estate and to money and to stocks and to bonds and everything else like that. For what reason would they not have the capacity to access digital assets? So it was. Thank you for the question, but again, it was almost universally positive. There was nothing negative. There was no reason that anyone could come up with as to why we would not do this.
Thank you. And so my next question was written as follows: what are the primary benefits of this legislation? And I think you've highlighted that well. It's self-evident with the title of the legislation. You indicated is it's in and of itself that describes what the bill is setting out to do. So I guess I could rephrase my question as without this legislation, or in the past, have there been roadblocks for executors or administrators, trustees, fiduciaries to access digital assets, and that this legislation will facilitate? Because I think over the years that we've still been able to divide up estates and the like with digital assets, but maybe you could go over maybe some of the feedback you received, the roadblocks that this will help fix.
A fiduciary would have access to all these assets in any event. But unfortunately, there are accesses that are done by computer. There's rules. I mean, if you do not have the username and password, there isn't any capacity to, mail a certified copy of the will to some post office box in San Jose, California, to get you digital access to something. So this is uniformly done across North America to do that. And it's like many things. This username, password, digital access, it doesn't comprehend letters testamentary. It doesn't comprehend this type of stuff. So this is enabling legislation, which is being done across the board in provinces, and as I say, I think 47 of the 50 states are already have undertaken this. So it opens that door, which otherwise is not open. I mean, try to get on a web page without a username and password, and then all of a sudden there's a message sent with a 6-digit code, and you got to type that back in. But if you don't have the number that sent it to you, and all this sort of stuff, so it's just, again, a fiduciary needs access to digital assets, and you can, I'm sure, member, can see the cumbersome nature of it if you don't have this kind of access.
So could you indicate if regulations have been drafted in support of this act and what matters might be dealt with under regulation?
The ability under a statute to have regulations is a common enough thing. There is no regulations contemplated here. It gives the power to implement regulations should it arise, but there is nothing that the department sees that would make that necessary today. There are no draft regulations. There are no plans for any regulations. The Act itself should handle the situation easily.
And so, dealing with the Act, different provinces, different states are implementing this legislation. You use the example of writing a letter or something to a firm in San Jose where a tech company might be headquartered. Does this legislation, does it bind that firm to give out the information or enabling legislation in that matter, or would the local legislation where that company would be headquartered determine what they can and can't do?
As you know, under conflict of laws, we have no capacity, the legislature of the province of New Brunswick has no capacity to bind another jurisdiction. That's just by operation of law. But if everybody agrees that our courts and our fiduciaries have access to these kind of assets within the scope of their authority, and if everybody does that, then it will make it easy. But you're quite correct when you point out that there's no capacity for the province of New Brunswick. We can't pass a law here that is binding on the province of British Columbia or the state of Louisiana or whatever. We have no capacity to do that. But if everybody does this, then the courts, fiduciaries, administrators will have access through universal application.
So you use the example of sending a letter. You send a copy of the will to a tech firm in San Jose. Could you give some examples on how a fiduciary would access digital records? Is that how they would do it, or are there other means that could be used under this legislation?
Thank you for the question. I refer you to Section 8 of the bill, and the heading there is Request for Access to Digital Assets. That's the form of the request. And so if you follow through, you will see that the Act sets forth very clearly the procedure to follow. I can read it all, but I know that you're a person of intellect and ability, and it's right there, and it lays it out: certified copies, letters, probate, court orders, things like that. So Section 8.1 sets forth that procedure.
And so just coming back to that example where you'd be requesting this information from some organization outside the province, but we're having, reciprocal types of legislation, does it facilitate things for an outside company knowing that the legislation here allows for fiduciaries to access this information, for them to release that information to someone here? Is that necessary for them to release that information?
Now, again, we have no control over what someone does in another jurisdiction. I mean, we can't pass a law with respect to the speed limit in the state of New Jersey. We have no capacity to do that. But what it does do, it does set forth a universal or across the board similar legislation so that every jurisdiction would have the same type of thing. But again, I don't have any perfect answer here as to what is going to happen in every coulda, woulda, what if, whatever. You can work your way to the point of screwing yourself into the ground on this kind of stuff. There's always a scenario that somebody might say, yeah, but what about this? Well, yeah, what about this? This is consistent with North American legislation. Within the authority of this legislature, this is all that we can do. We cannot bind other jurisdictions. We can't make people do what they don't do. I would encourage people, when they're making their will, they should have a list of digital assets. They should have usernames and passwords, and so that this type of stuff is then access to their personal representative. But if they don't, this is the best that we can do in the circumstances, bearing in mind that this is all we can do in New Brunswick, and we can't bind anything outside of New Brunswick. But if everybody does it, and there is a plan in other jurisdictions for digital assets, and the law in that other jurisdiction says, where a fiduciary with certified copies of a court, letters probate, has been granted, this, when you supply all that, then hopefully consistent jurisdictions will respond accordingly. But as I said, there's no guarantee that we can do that, and but there is a reciprocal jurisdictions, have a reciprocal relationship to other people's legislation if it's consistent, and hopefully that will work. The point being, the present situation, there is a gap in digital assets. This is the most that the province of New Brunswick and that this legislature can do. And if everybody does this in all the jurisdictions, then hopefully personal fiduciaries will have access to these kind of assets.
So my next question, I think you've answered it. It was written as this: will financial institutions and other entities who are custodians of electronic records have to comply with a request for access under Section 8? I guess you've answered that question. It really hinges on reciprocal legislation between all jurisdictions for a perfect world in terms of accessing digital assets. And from what I understand, this legislation, New Brunswick legislation, is not necessarily binding on entities outside of this jurisdiction. But in a perfect world, everyone would have the same legislation and the same way of doing business in terms of accessing digital records. Is that a safe assumption?
Yeah, it is a safe assumption, and it's a good assumption. With respect to banks, for example, banks do business in New Brunswick. Banks have web pages in New Brunswick. Banks have branches in New Brunswick. They have custody of digital assets in New Brunswick. So, for a New Brunswick court to issue letters testamentary, take it to your bank, and they look at it, they do, and they follow through because the bank operates here. It's a little trickier for organizations that don't operate here. There's some kind of a loyalty or e-books or Spotify or whatever you call all these different things. You know, New Brunswick doesn't have the capacity to do that. But financial institutions that do business in New Brunswick, then I think that they would see this legislation for exactly what it is, and they would cooperate in accordance with Section 8.1 and the sections requesting access for digital assets by a fiduciary.
And so could you indicate what protections will be put in place to protect financial assets and privacy?
Privacy is you know, the Privacy Act, privacy legislation. There's abundant pieces of protection there. Given the potential nature and extent of information that can be kept online, you know, some people may not like unfettered access to their digital assets. But again, make your will and say what it is you want. I'm sure the member you're familiar with provisions in wills where they set forth all the powers to buy, to sell, to dispose, to banks, to this, to this, to this. Those are very, very broad powers that are set forth that a fiduciary would have. But there's several layers of protection here. You could access is limited here only to fiduciaries, okay? This isn't anybody who wants to access this. As I said in my opening remarks, you must be a fiduciary, not just anybody who's interested. You know, somebody dies or somebody's infirmed or whatever. Somebody says, oh, well, I'm going to look up and get their frequent flyer points. No, you can't do that. It goes back to the definition of a fiduciary. Only fiduciaries can do this. And that is a representative appointed by the account holder, and a person who has a legal power of attorney under the Act, a personal representative of a deceased person, a trustee, or other types of personal representatives. So there's a limitation because the definition of the word fiduciary is limited. And these fiduciaries must also act in a manner consistent with their appointment. They are in a position of trust. If they breach or violate that trust, they are subject to legal action. They could be subject to prosecution, many things like that. Also, section, I think it's 4 sub 2, is governed, there are limitations that can be put in place by the account holder. And access will be governed by a provision in the service agreement that limits access and only put in place by the account holder by specific action. So there's any number of things here that can be done. It's not open season on anybody. I mean, you can't just phone up and say, hi, so-and-so's died, I'd like access to the things. There's, you know, it goes back to the definition of fiduciary. So, yeah, there are provisions for privacy here. And again, I refer you to Section 4 of the Act as well for more detail on that.
Thank you for that, Minister, through the chair. And I'm getting close to the end of my questions here. And I think it's good legislation. It's something that needs to be addressed. If we can make life easier for executors and administrators of estates. I know our family recently went through the death of my mother-in-law, and it was our first experience as executors of an estate, my wife being the executor, and, hitting some roadblocks and, not necessarily even having to deal necessarily with digital assets outside of dealing with banks and that kind of thing. So anything we can do to make it easier for fiduciaries to access what they need to do to execute the estate, I think is good legislation. One area that I had highlighted was with respect to if there would be a service agreement between a provider and an account user, and that there might be some restrictions in a service agreement. Does this legislation help circumvent what might be, found in a service agreement with respect to restrictions?
Yeah, I refer you again to section 6.2, that it does in fact do that. If the act is complied with, any provision in the service agreement that limits the fiduciary's right to access digital assets is void. So this again, a service agreement cannot invalidate the law. Two parties can't agree that we will not comply with the law of the land or the law of the province. So that's exactly what this is for, and why it's, I believe, necessary and appropriate for that very reason, so that personal representative of fiduciary can access these assets.
And my last question I had was coming back to the jurisdiction issue that we had discussed a few moments ago. If there is a dispute, what jurisdiction would be, would have jurisdiction over the matter in a dispute resolution? I understand it might not be unique to this legislation. It might be a situation that can happen under any type of dispute. But with respect to digital assets, how does legislation ensure that New Brunswick would be the jurisdiction for dispute resolution?
The intention here is to try to get, and I refer you to section 7, to get the jurisdiction of the New Brunswick court. And as you know from any study of conflict of laws, there are certain rules with respect to jurisdiction: where the person was domiciled, where they lived. Very often, you and I could have an agreement and say this agreement shall be governed by the laws of the province of New Brunswick, and you choose your jurisdiction. Your jurisdiction exists by operation of law, or in the case of this, the jurisdiction by statute where possible, so that the deceased person or the person that the fiduciary represents, power of attorney or committee or whatever, would have access to relief by the New Brunswick courts because they're domiciled here, they have assets here, and are deemed to be subject to the rules here as best we can. As I say, as best we can.
Thank you very much, Minister, and to your staff here with you through the chair. Those are all my questions on this bill.
Thank you very much, Mr. Yeah.
Thank you, members. As usual, your questions are thorough, helpful, and I always appreciate a good question. And thank you again for the work that you've done on this, and just another pleasant example of me being able to deal with somebody on the other side in a positive and a good way, and I want to thank you personally for that.
Thank you, Minister. Any further questions? Minister or member from Fredericton South?
Thank you, Mr. Chair, and good morning. Good morning to the Minister through you and to his staff, colleagues. Mr. Chair, I mean, I've gone over the bill, and it seems quite well done. In terms of meeting its goals and objectives, the only thing I have a few questions on is the definition of digital asset, in the sense that obviously, and I'm sure the Minister and staff have thought about this, of course, but it covers the landscape of what needs to be covered. So I've read the definition over a number of times to try and think about this, and I guess when it talks about a record that is transmitted or stored in digital or other intangible ways, and gives examples, electronic, magnetic, optical, and other similar means. So that would seem to cover it, but what if a fiduciary would it still cover it if a fiduciary was trying to get access to shut down a Facebook page? Right, so, or a website that the person had once operated. So do those get considered to be records? Will they be covered by the excuse me, the definition of digital asset, or might someone argue in court that they don't actually meet the test of a digital asset because they're not data per se? Anyway, I just want to make sure that that's covered, that if someone, the fiduciary says, okay, we need to shut down this, you know, basically remove the Facebook. I don't even know if you can, but Zuckerberg would tell us, I suppose, but at least whatever is possible in terms of shutting it down or removing a website or access to a website. So it's those kinds of things, Facebook's pages, websites, YouTube channels, that kind of thing.
Digital assets, basically, the intention here is to cover everything that is digital, everything. And it's technology neutral in the sense that you don't say, well, we're picking this digital asset, but we're not picking that digital asset. It is digital assets across the board. I would say digital assets that haven't even been invented yet. This would include. In the definition, which I know you've read, any record that's created, recorded, transmitted, stored in digital or other intangible form by electronic, magnetic, optical, or other similar means. The intention is to be as broad a definition as you could possibly get. Any record or information that exists in electronic form. So the intention is to cover everything. And a fiduciary has all the powers, unless those powers are restricted, they have all the powers of the person for which they act. And if you have the capacity to close your Facebook page, then your executor would have that same capacity. If you wanted to close your Twitter account, your executor would have that capacity, because it is the capacity of a fiduciary to have access to digital assets in the same manner as if the original deceased or disabled person could do so themselves. I'm not technically equipped, to get into a discussion as to, well, it applies to Facebook, but it doesn't to YouTube or to this or to that. All as I know is that the intention of this act is to define digital asset as broadly as it can possibly be defined.
Mr. Chair, to the Minister, I appreciate that for sure, and I guess it's difficult sort of to anticipate, but important to anticipate various possibilities. And so has there been any jurisprudence so far in other jurisdictions that have comparable legislation or have had it for some time where on this matter it's been challenged, where it's been argued that, well, this digital asset actually doesn't reflect, that isn't a record or isn't covered by the legislation? Is there jurisprudence or efforts so far to tackle that in court or not? It would be good to know.
We can speak to issues in Canada to deal with other provinces. There haven't been any legal cases or jurisprudence on it. It is just the Uniform Law Conference of Canada have had feedback that there are problems and that there are issues with digital assets. And so everybody is in agreement that a trustee, an executor, a power of attorney should have access to digital assets the same way they would any other asset. It's an asset, but it's an asset that is new. I mean, when we were kids, there was the family album. My father had an extensive library, and what's the family album today? It's digital. Libraries are digital. I mean, I remember when I left my law practice as a partner in a firm, one of the issues we had to discuss was the value of the library. Well, guess what? Today, libraries don't have any value. They do to me personally, because I like books and I like to read, and I was raised to do so. But in terms of evaluation for an asset, for example, with a law library, you can get everything on your phone that you can get in rows and rows of books. I'm not giving up on books. I don't think that you can, there's something about a book that I don't think that they're gone, but I just say 25 years ago, there were no digital books. There was no, you look to buy a book, and I want to buy a book to read, and I can't get the book. I can get it in Kindle, I can get it in all these other things. I just want the 300 pages that I can turn and read, but, not available. You can get it in Kindle. So that's the world we live in today, and So I can't speak to other jurisdictions in the United States. You know, there's 50 states and their legal system, you know, they sue each other the way, you know, I change my dogs, you know, they're a litigious country. But in Canada, there isn't any jurisdiction or any jurisprudence on the matter, but it is universally across the country realized that these digital assets are in fact assets, and fiduciaries do need the capacity to access them.
Thank you to the Attorney General, to the Chair. The value of libraries, we could have a discussion about another time, I guess. They are quite important. As I imagine, the Attorney General agrees that I understand him making the point he was trying to make there. So the last thing on the definition really is this, and it's maybe a bit, feels a bit picky, but again, in terms of making these things airtight, at the end of the definition of digital asset, when it refers to the mechanism for storing, transmitting, and so on, by electronic, magnetic, optical, or similar means, is there actually a reason to say similar means? And once again, because of the way technology for this moves so quickly, does that create a constraint that might mean you would have to come back at a later date and amend this if there's a means of doing these things that is not similar to electronic, magnetic, or optical storage?
As I said when I answered a couple of questions ago, the intention is to make the definition as broad as possible. From a drafting point of view, if you don't have what's called a catch-all, if you simply have A, B, C, then it's A, B, C, or nothing. A, B, C, or such others similar. Will this be amended? Maybe. I don't have a crystal ball here. I know that a lot of good legislation over the years has been brought in by different governments, and from a practical point of view, it has to be adjusted. They bring in amendments. Well, this didn't work, but this did, that's and that. So amending a bill is pretty stock and trade for what we do here, and you know, the drafters can do the best job that they can as they enter this digital age. And I can't say that every single possibility, every possible nuance, inflection, or whatever will be done so that it'll never have to be amended and it will be good forever. I'm not able to say that. I'm able to say that this is the best the drafters have been able to do with the situation as it relates to digital assets. And if, as technology marches forward at a remarkable pace, if we have to come back and amend the act to include something, I'm sure that will be done. And if we don't, then the catch-all phrases, such as all other or similar to, will operate. But again, I can't speculate one way or the other and say that under no circumstances in the future will we ever have to amend this act, because every single possibility, I mean, we're talking about, you know, technology today that is every day, and it's, you know, was something off Star Trek 25 years ago, but such is technology.
Thank you, Mr. Chair. To the minutes, to the Auditor General, to the Attorney General, I'm sorry. Before I let go of this, and this is my final question, I just question why in the definition of digital asset it wouldn't refer to by other, simply by other means, rather than constraining it to similar means, because then it links to the text beforehand by electronic, magnetic, and optical means. So if it read and then or other means, it would be more open-ended and not constrained to the previous examples in the definition.
The word similar is there, in my judgment, because it has to be electronic. If you just said or other means, well, that would be much broader than what this is intended to do. And the word similar, I believe, is there because it ties into the fact that it has to be electronic and it has to be digital. And again, the encouragement of staff to, we need to reiterate the definition of digital asset is intended to be technologically neutral and sufficiently broad to capture all types of electronic stored information. So similar, I believe, is there, not by accident, but by design.
To the Attorney General and the staff, Mr. Chair, I appreciate that. I appreciate the exchange on what may seem like small details, but I know as the Attorney General recognizes definitions matter in legislation and language matters in legislation, so that was the one thing in the bill that was sort of on my mind, and other than that, Mr. Chair, the bill is, I think, a good one, and certainly support it.
Thank you.
Again, I would just thank the leader of the third party for his courteous decorum, and thank him for the work that he put into his questions, and always appreciate it. Thank you very much.
Thank you, Minister. If there's no further questions, we'll just ask staff to step out. We'll do the vote. Is it the pleasure of the committee that Bill number 19, Fiduciaries Act and Digital Assets Act, stand as presented, and that I report the bill as agreed to? All those in favor, please say yea. Yea. Against, nay. Carried. We'll take a 5-minute recess. call the meeting back to order. Is it the pleasure of the committee to take into consideration Bill number 20, Supported Decision-Making and Representation Act? For it, yea? Yay. Against, nay? Carried. Mr. Minister, do you have any opening remarks?
First of all, I'd like to introduce to my left Michael Hall, legal counsel for the Law Reform Division, and to my right, Charbella Wad, senior ADM, Department of Justice and Public Safety. This bill before the committee, the Supported Decision-Making and Representation Act, I believe is a good piece of legislation. I believe it's overdue. The original act dealing with this was passed in 1943, and we've come a long way with respect to infirmed persons since 1943, to be sure. Briefly put, the law in its present form deals with a person who is either infirmed or not. It's like a zero sum. You are either 100% disabled or you are 100% able. There's no particular middle ground. We are, with respect to mental capacity, are trying to move or want to move from an all or nothing approach to, with respect to mental capacity, to a functional approach. And the functional approach means that a person's capacity is assessed regarding their ability to make certain decisions in some areas, but not in others. From personal experience, I know of a situation quite close to me where, as a person aged, the person lost a lot of interest in finances. Oh, let so-and-so look at it. I'm not interested in that. But many other aspects of his life he was very interested in. Well, the law as it is today is not able to deal with that. It's interesting. I received a phone call yesterday out of the blue from someone who has a career in working with disabled people for the sole purpose of thanking me for bringing the department, me, for bringing this legislation forward. And the person whose life's work is dealing with handicapped people said that this is long overdue, it is right, it's proper, and there are some people who are handicapped in certain aspects of decision making, but they're not in others. And to treat a person either fully, totally competent or completely, totally mentally incapacitated is not accurate. It doesn't reflect reality. And this person just out of the blue called me at home yesterday and thanked me for the legislation. We've consulted again with many people who are involved in the treatment and care of people with disabilities. And it is, support for this is almost, it's universal. It's high time. It's time we leave 1943 with respect to mental capacity, and that we have a statute which reflects reality as opposed to a bygone era which is no longer relevant. So I look forward to the questions. That's the reason for the legislation. It gets rid of the all or none approach. It allows the individual to be involved in decisions that their representative is making. And the Act will establish options for supported decision-making where a person is appointed to help another person make decisions rather than actually making them on their behalf. It's good, proper legislation, and I must say, Mr. Chair, I'm proud to bring it forward, and I appreciate the work that staff has done in this regard.
Member from Moncton Centre.
Thank you, Mr. Chair, and thank you to the Minister. And you said in your preamble that there were some consultations done with respect to this legislation, and like many that come forward from the Office of the Attorney General, the Minister indicates that the usual suspects are consulted, and I'm wondering if you could give us a brief outline of what consultations did take place in bringing this bill forward.
The consultation on this bill has been very extensive. We started a group called Inclusion New Brunswick that was formerly called the New Brunswick Association for Community Living. I have personal involvement with that organization and the people working there and the commitment they've made and the work that they've done. It's quite remarkable, really. They're to be thanked for it over and over. Extensive work was done with the Premier's Council on Disabilities. Consultation was done with Ability New Brunswick. Consultation was done with the public trustee. Consultation was done with the legal community, both the practicing legal profession and consultation with judges on this. Consultation was done with the New Brunswick Medical Society, consultation with the Nurses Association of New Brunswick, consultation was done with the College of Psychologists. About everybody that we could think of, we consulted with or put out offers to consult, and we don't hear, but we've heard from almost every legitimate group, and the response is universally positive. I'm not talking 90-10, I'm talking universally positive. Many made comments which were constructive and helpful, and those comments were taken into account. And I need to specifically refer to the submissions and work that was done by Inclusion NB, which were particularly helpful and which were in large measure taken into account with respect to this statute.
No, it's great. It sounds like many different organizations and stakeholders have been consulted, so that's a good thing, and that they do bring positive remarks around this legislation. And as you mentioned in your preamble and in your second reading statement as well, you know, a number of issues that are being addressed in this legislation with respect to you know, the all or nothing approach, I think, is something that is welcome. Even the wording, you know, the representative being a committee in the old legislation, I never understood what a committee meant. You know, it sounded like it was some formal group that were making decisions on behalf of a person. So to have it now known as a representative, I think is a good thing. And then, you know, to have it you know, where they can have supported decision-making, help in making decisions, meaning, you know, they have some capabilities, they're not completely incapacitated, like the all-or-nothing approach that you mentioned. So is there anything else that has not been addressed where this legislation is coming to a benefit in making things better?
Thank you for the question, Mr. member, and I am comforted and proud to say there isn't. We have, the department has canvassed and communicated and reached out to everyone we could possibly think of. The people that we reached out to, they said, is there anyone else you think should know about this? Please pass it on. And I must say, I've been, you know, I'm entering my second decade in public life, and you know, I haven't seen many pieces of legislation which have been so extensively consulted. I know when I first brought this to P&P, there were many questions. Well, did you ask these people? Did you? Well, we will. Well, we will. Well, we will. And it's comforting to know that every stone was turned with respect to consultation, and at the same time, that the result of that was uniformly and universally 100% positive. So for an Attorney General who's bringing a piece of legislation forward that I can be so completely supportive of, because the extent of the consultation, the experts have been listened to, feedback was received from all different groups, and it has resulted, the culmination of that is this statute, which I think is, or this bill, I should say, which I hope becomes a statute, which I think is very good. And again, I know the member opposite, being a man of principle and has a heart for this kind of thing with mental health, and I know that, you know, your family background with your father and whatnot, how close to this you would be, and what a history and experience you would have here. And so again, to hear your words in support are you know, really quite reassuring, and I want to thank you for that personally.
Thank you, Minister, and I appreciate those comments as well. You know, we're always working together here, and I think everybody's heart is in the right place when it comes to, you know, vulnerable New Brunswickers and we're trying to make a difference, so thank you. This legislation is designed to replace the Infirm Persons Act. Is there any other existing legislation that governs adult guardianships that this might be addressing or replacing?
No, there's not.
And so with respect to this legislation, I'm wondering about the process. Is this something that an individual would be requesting assistance, or is it an application that is done by a person requesting to become that decision maker? And I ask that because, you know, when I think about a power of attorney, for example, someone can give the power for someone to take care of their personal affairs, the property portion of that, but then there's also the personal care portion, which is only triggered, you know, if the person is deemed to not have the mental capacity to make those decisions. So is this something that someone can request, and it's conditional upon, you know, the mental capacity coming into play, or is it something after the fact where an individual is already deemed, you know, to have a mental capacity issue that is requesting help, or the person is requesting that assistance?
three possible scenarios with respect to appointments. The first one is the appointment of an assistant. And that appointment would be made by the individual, subject individual. The person may say, look, I need help in this area. I can't do this myself anymore. I need some help. I experienced that with my mother, who is 102 and still alive and sharp as a tack, but by her own admission, she says, look, I need help in areas, and we have someone to help her. The next one is a supporter. And that person is court appointed. And again, a person would apply to court, a family member, someone who has a close affinity, they would apply to the court for the supporter. And the third one would be the full personal representative along the lines of the old definition of committee. And I'm like you, member. I don't know who came up with this word committee, but it confused me when I heard it in law school for the first time, and it's confused me ever since. And I think representative is better, and I agree with you totally that it's long overdue. A committee, by its nature, seems plural. There's got to be more than one person and things like that. It just doesn't seem to fit. I think it goes back to a translation in a different legal system or something. And that would be the court-appointed personal representative to carry. Those are the three types of scenarios which would result in the act coming into effect.
Yes, the new definition is definitely much more of a human touch. When when you think of committee, like I said, it's some type of institutionalized type of operation there. Yeah. So, with respect to the first scenario, appointment made by an individual, is that something that would be effective immediately or conditional upon some type of situation happening like you would see in a power of attorney?
It would be immediate upon appointment by the person, and it's specific to a particular area of assistance. The person themselves would acknowledge that they need help, and the subject person would be making the appointment of the assistant themselves.
And so, with respect to capacity, as defined in this Act, is there a difference between capacity in this Act and what we called capacity in terms of making a will, the testamentary capacity? Is there any difference between that and capacity found in this Act?
It's a more detailed description in the Act than what we would have at common law. In common law, the person drafting a will and taking signatures has an obligation to make sure that the person is mentally competent, and that's a common law principle that's brought forward through jurisprudence. The Act specifically deals with it in a more comprehensive and specific way.
So, dealing with the other two scenarios that you outlined, the court-appointed supporter or the full-fledged personal representative, those, I imagine there's a procedure to follow and an application process and a ruling. A ruler would have to decide on the issue of capacity. So, could you outline what is the, is it the court of competent jurisdiction here that would be overseeing these matters?
The procedure will be, the actual specific procedure for the court appointed will be set out of the rules of court, what exactly is needed. Again, you don't just go to court and get a stamp. You have to convince the judge through evidence that there is, in fact, reason to do this. And under the rules of court, there will be, which will be changed, there will be, in order to proceed with the second two, the court appointed, there has to be a capacity assessment. And the capacity assessment must be done by a medical professional. It must be done by a physician. It must be done by a nurse practitioner or a psychologist trained in that area. So it isn't a matter of just going in and say, here, sign this. There is a threshold of evidence, arm's length, that has to be done by a person who has specific expertise to provide the court with the sufficient capacity assessment. I remember years ago having done a couple of these. I remember going to court and being grilled by the particular judge about, well, what about this and this and this and this? And the judge actually, in the case that I dealt with, actually wanted the physician to come and answer questions. So there is a standard, and I think the judiciary have historically conducted themselves extremely well in this area of capacity. I mean, again, they don't throw this out willy-nilly, that's for sure.
So my next question was going to be around that, if there are specific processes or guidelines to evaluate capacity. You mentioned the rules of court. Did you mention that there would be changes to the rules of court or a new rule implemented? And maybe give some details around that and a specific process or guideline to evaluate capacity.
Yeah, there's a rule right now for infirm persons applications. We'll replace that.
Yeah. The rules of court have provisions now for infirmed person. If this passes, then the rules of court will immediately be amended consistent with this statute, and it will again cover the actual specifics for the capacity assessment criteria that must be presented to the judge as evidence for doing this. But you know, it's kind of chicken and egg. You know, you do the enabling legislation, and if that passes, then you do the rules of court, which is the procedural.
And moving on to, I guess, when you're going through this application process, what safeguards would be in place to ensure that a person making an application for decision-making for another is not in a conflict of interest or acting on a personal interest that are not in the best interest of the person being assisted? Is that covered in the legislation?
Good question. Again, that, not to be evasive here, because I'm not, but the courts do their duty here under the rules of court. And it would be like any other application to court, the applicant must prove and satisfy, or the judge doesn't rule in your favor. And the judge may well say, you know, I want more information. The judge would have to make sure that the person being appointed, whether it's a supporter or a representative, has the necessary ability, training, education, reputation to carry out this job. Generally, it's a family member. The more complete the application, the more likely it is, if you have an application that is signed by all the siblings of a particular person, With respect to one person, well, then that's easier than if just one person comes in. A judge may say, no, are there any other siblings here? Well, I want them served, and things of that nature, and the applicant should do that in any event. Should serve everybody that has any kind of an interest in the person. But again, it is, the good thing about this is that it is the court that has to issue the order. It is not somebody saying, you know, self-appointed representative, self-appointed supporter. No, there is no self-appointment. It is an appointment of the court based upon evidence presented to court, satisfactory to the judge, that the order should be issued.
Could you indicate, I know we talked about having, you know, a medical expert to give evidence on the issue of capacity. Could you indicate what other criteria would be used to determine whether or not an application for assistance will be granted? Is that found in the legislation, or will it be amended in the rules of court?
To the member opposite, yes, indeed. You are quite correct in the presupposition of your question. I would refer you to Section 37(1) and Section 37(2) of the Act. And it is very clear that the appointment, the court must satisfy itself in Section A, subsection 1, 2, 3, B1, that each proposed representative consents, is eligible, is suitable. The person does not have the person doesn't have capacity in their care, their financial matters, personal care. You know, it's very, very extensive. As I say, it just isn't anybody that walks in and gets this. There is a threshold of proof, and if it would seem to me, as I read this, if you are unable, when applying for an order, to meet the legal threshold as set out in 37(1) and 37(2), then it strikes me, if I were a judge, I wouldn't issue the order.
So my next question is around the fiduciary duty that a person appointed or court appointed to act as a representative or a supported decision maker. Are there any provisions in place to ensure that a person seeking an assistance order acts in a responsible way as a fiduciary?
For the question, I would refer you to Section 43 and 44, which are under the heading duties. And those duties are set forth in 43(1), 2, 3, 4, 5, 44(1) A, B, C, 42(2), 42(3, very, very extensive. As basic as 43(1), a representative shall act honestly and in good faith and shall exercise all reasonable care. Well, those words have legal meaning. Standard of care. Representative shall not act for their own benefit or for the benefit of any other person other than the represented person. So again, I'm not going to read it all through. It's all there, and it's pretty extensive, and it's pretty comprehensive.
Does that also include remedies that would be available if an assistant breaches their fiduciary obligations?
I refer you to section 49.5, is that a person can make an application for a review of the conduct of the representative, and they can make the application to court continuing, terminating, varying the order, and particularly under 49.5D, the court can order the representative or the support person to reimburse the representative or any other person for any loss incurred. So a person who takes on this responsibility not only takes on the responsibility, but they take on the liability for not acting appropriately, which I think is good.
And you mentioned earlier about the rules of court. Some amendments might be required to the rules and bringing these applications forward. Could you identify the process for challenging an application order? I imagine that would be set out in the rules. If there's timelines for filing and serving and responding and the like. So what is the process for challenging an application?
As I said earlier, the process will be the enabling legislation, and then the rules of court will be amended thereafter. And although those changes to the rules of court have yet been done or approved, because this has to be done first, but I can tell you that the rules of court will contemplate on this application the capacity assessment, an obligation to serve all interested parties, an obligation to serve all family members, and basically the obligation on the applicant to serve everyone who could reasonably be expected to have any interest or any concern with respect to the matter. So if everyone, there's an obligation to serve as many people as you can, and somebody there shows up, says to the court, well, I don't think you should do this or whatever, well, then that's where the courts kick in to carry out their duties. But as far as the rules are concerned, I mean, I personally feel that the notice of this application should be as extensive and as complete and as widespread as you could possibly expect.
And would there be any accountability and reporting requirements for a representative or an assistant under the legislation?
Absolutely. I draw your attention to section 46 under the heading Records. A representative shall. We all know from our law school days, we learn early the difference between may and shall, you know. There's no discretion here. A representation shall keep, and it goes on to talk about any records prescribed, complete accounting, provide the records referred to, and things of that nature. So absolutely, you don't just do this out of a shoebox. There's an obligation to keep proper records, and those records are to be 46B, shall be referred to the court or other person if ordered to do so. So they're subject to review, and you just don't, as I say, you're not doing this out of a shoebox. There's a real obligation here to do things right, to do things transparently, to keep proper records. Which, as I say, it's right and proper that that is the case.
Are there any provisions that would put constraints on a person given these powers? Are there any constraints that might be placed on an order granting the power of assistance?
I refer you, member, to section 41.4, which lists restrictions. A representative shall not exercise power, and it lists the things that they will not do, and the court may apply restrictions as well. The restriction may be the judge may well say, you want to sell any land, you bring it back for approval. They could put a dollar value on any transactions below this or that or whatever. And so there's restrictions on the exercise of powers enumerated in section 41.4. And the court has every right and every ability to add restrictions to the order as they may see fit in the circumstances.
And is there anything in the Act that deals with a person wanting to revoke an appointment, whether it be a self-directed appointment or a court appointment? Is there a way to revoke an appointment, and is there also a way to challenge, possibly after a court order, to challenge that if if something would raise flags that a person would want to challenge?
You had asked about revocation, termination, review, resignation. I refer you, first of all, to Section 16 of the Act under the heading Revocation, Resignation, and Termination of Appointment. 16 specifically enumerates that. I then refer you to Section 31 under the heading Resignation and Termination of Appointment. And it sets it there. A person may resign, and a person may, the decision maker could terminate. The court could make an appointment terminating. Also, Section 32, there's provision for the application for review of the order. The following persons may apply to the court for a review: support person, decision, public trustee, any interested person over the age of 19 can make an application to the court for review. And then I further draw your attention to Section 48 under the heading Resignation and Termination of Appointment. And again, 48.1, 48.2 give further situations with respect to that. So the Act, fully contemplates the very questions that you've asked, member. Thank you very much.
And does the Act dictate who might not be eligible to apply to be an assistant outlined in the legislation?
Again, member, I draw your attention to Section 40 of the bill under the heading Eligibility. And that section goes through who is eligible, which people are eligible in certain areas, which maybe not in others. And it lays out those particular criteria. And I think your question is very clearly answered under Section 40, eligibility.
Thank you, Minister, through the chair. And, it looks like many of these are addressed in the legislation, and you're able to point out the different sections, and I appreciate that. One question that comes to mind is whether these changes will increase the workloads of the courts. I know we know that the courts are already backlogged, and with the child protection cases that are now seeing priorities. Is there any expectation that this could increase the workload, or is it just it's modernizing legislation that's already applied and that it might not necessarily change in terms of workload?
Yeah, we're changing the criteria for the better, I would say, but I don't think it's going to produce more applications. And the other thing about it is it's a chambers matter. So it's not like booking a trial date and booking time out in court and things like that. Judges set aside chambers days for applications like this. And I don't see any increased burden on the judiciary because of this. It would be a chambers matter. You book your appointment chambers, you go, here's your petition, here's your evidence, here's your this, and so I don't see it as being overly burdensome to the courts.
So is that the nature of these applications? I've never done one as a practicing lawyer. It's a matter that would be a chambers only matter where you'd have affidavit evidence and a petition. Is there any circumstance where you would have court time where you'd have to hear from the expert witness if it was challenged, kind of thing?
The allocation of time would be the responsibility of the Chief Justice to allocate time. Again, the more complete the application, the more thorough that it's done, the less likely a judge would order any kind of a hearing. If the application is thorough, the service is thorough, presentations are thorough, the capacity assessment is done by credible representatives, it shouldn't take very much time. If the judge sees some things that he doesn't like, he may want to make more time or have more time, but it's, again, this would be mostly by like a desk application on a chambers matter. And if done right, it should be fine, and if the judge sees fit to call for further information, that's the discretion of the judiciary. And so the more complete the application, the less likely for that to occur.
Thank you, Mr. Chair. Those complete my questions, and I thank again the Minister and his staff for bringing this forward. And I think, you know, modernizing legislation in this area is welcome news for the province. So thank you.
And member, thank you again, as usual, for your thoughtful questions.
Thank you very much, Minister. Any further questions? Member from Fredericton South.
Thank you, Mr. Chair, and if I may take a moment, I just want to wish all those with some Scottish heritage in the chamber and those watching at home today a happy St. Andrew's Day. A little while ago we heard Sandy Gordon on the pipes outside of the legislature while the flag, the Scottish flag, was being raised outside the Legislative Assembly. It doesn't have quite the same je ne sais quoi like St. Patrick's Day does, but all the same, all those who take pride in their Scottish heritage, happy St. Andrew's Day. Mr. Chair, I specifically want to ask about the Section 3 on capacity. And let me say, first of all, to preface my remarks, one of the things that really impressed me by the bill was how respectful it is about recognizing the real capacity of many people, the real agency of many people as persons to make decisions in their own best interest, even when in the past those same people might not have been regarded in the same manner given their particular situations. And so this is impressive in that way. I would say, and it's also impressive that Inclusion New Brunswick has been involved and has stands squarely behind the bill. You know, in my time over the years here in the Legislative Assembly, you can really pretty quickly determine see bills that are well put together, well thought out, where there's been a lot of consultation behind them, and certainly this Bill 20 on supported decision-making and representation fits into that category. So I don't have that many questions, but I do want to ask about the section on capacity, Section 3. So this reads well to me. What happens in the instance of someone who has short-term memory challenges, that they meet all of these tasks? Is that material at all to this bill? In other words, they make a decision, they meet all of the conditions here, a day later they can't recall making the decision, but they made it. So how does that how does this bill anticipate that? Does a decision in those instances, are those people still considered to have the capacity to make decisions or not?
It would depend on the circumstances, and it would be in an area of mental health medicine expertise. A person may make a particular decision, I suspect today, although they were competent to make that decision, it was a decision that they wanted. The fact that they didn't remember the next day may or may not affect that. It would be the subject matter of the decision, circumstances of the decision, and to what extent a healthcare professional trained in the area would say, well, no, that's okay, they knew, they just didn't remember. Ask them again, it would be the same answer. Ask them again, it would be the same answer, as opposed to all kinds of different answers. And I think a medical professional would be called upon to say, a person does or does not have capacity. The legislation, the rules of court, the duty and obligations of a judge have a lot to say, and that would be a finding of fact, and it would vary in circumstances. And that's just pretty much all I can say about it at this time, because I'm not a medical professional in this area.
Mr. Chair, thanks to the Attorney General for that answer. So what strikes me about the bill is it's silent on this matter. It doesn't really provide direction on that. A person may be very competent in making a decision according to the capacity provision here, and while they may not recall, a couple of days later, when prompted, they might, right? They might say, oh yeah, I remember that happened. Or if there was a document that, or some way of, obviously there would be of affirming the decision that was made, and that was readily accessible to them, that would also, in a sense, bring that memory back up. So as you said, it kind of depends, but the bill doesn't anticipate that. So unless I'm missing something, so I guess I'll ask this question specifically: is there direction in the bill that would provide those involved a way of understanding how this bill can apply in those situations? What does supportive decision-making representation look like in those instances? So I think it's really important, especially as more and our older population is expanding significantly, and there's more and more types of dementia, and you have this wrinkle where you meet all the tests on capacity, totally have the capacity to make decisions, but then short-term memory is not working so well, and so so I would hate to see, and this is my concern, I guess, more than anything about it, is a person meets the capacity test, let's say here, but those, say they're in long-term care or whatever, let's say they're in long-term care, and then those that work there and have daily responsibility for the resident on questions of decision-making automatically give them over to a family member rather than engaging the resident, when they might meet all these provisions under capacity. They have the capacity according to the bill, but because of short-term memory challenges that aren't addressed here, they're not. The bill in the end doesn't benefit them, when probably in many circumstances it should.
I may not be able to give the member much help here. Capacity is a question of fact, and it is a question for medical professionals. It is a question for proper assessments, and it is fluid. It's transitory. A person who has perhaps an early stage dementia could function quite well, but as their situation deteriorates, it can worsen. And what was capacity on day one may not be capacity 6 months later because of a deterioration in their health. Again, I'm not exactly sure what the member's getting to here, but again, the statute is enabling. It cannot comprehend every possible human nuance. That's what medical professions do, and the judges have a capacity assessment. They have thresholds that must be met, and an anecdotal thing about whether a person could, remember something on a Tuesday and then forget it on a Wednesday, but when prompted, I mean, I just don't know how I can take those kind of nuances into a statute for daily changes. These are medical professionals. It's a question of fact. It is a question of medical expertise. It is a question of experience and knowledge of the individual person. And it is a question of meeting a legal standard before a judge. So again, perhaps I'm no help to the member, but many of these scenarios we've dealt with all the groups, the psychiatrists, the psychologists, the community living, the Enable NB, and many of these scenarios we've worked through, and this brings us here. But again, capacity, as I say, it's not something that you can put in a statute. You can't say the statute says that this person has capacity and that the statute says this person doesn't. You cannot do that. The statute says capacity is a question of fact, and the ability to act is based upon evidence presented to a court on a capacity assessment made by medical professionals, made by family, made by loved ones, with respect to a particular subject matter, and to what extent that is unique to this and not to this. This is what the Act is meant to do, is to eliminate the all or none aspect to it.
So, Mr. Chair, the way then, I guess, the way I interpret what the Attorney General is saying, so in Section 3, where it says the person has the capacity to make a decision if the person is able to, A, understand the information that's relevant to the decision, and B, appreciate the reasonably foreseeable consequences of the decision. So if in the moment they meet that test, then they're considered by this bill, would be considered by this bill to have the capacity to make that decision. That's what I'm understanding, and that's fine if that's what it is. So if this is speaking to in the moment rather than temporarily over time, I think that would address the issue I'm raising here. So.
I agree with that, member. It is point in time, and I would ask that you look at in the Section 3 under capacity, Section 3.3b. It deals with that, lack the capacity to make a similar decision in the past. So it's point in time, and they may have been able to make this decision in the past, but they can't make it today.
Through the chair to the Attorney General, that addresses my issue and concern, and those were really my only questions around this particular issue of capacity in Section 3, and it seems to be well addressed. Maybe a little implied for me, but that's okay. I have confidence that the drafters and the Attorney General have considered that, and that this will address the kind of considerations I was raising. So thank you very much.
Thank you very much. Any further Comments, questions? Any closing remarks? Or?
I just would like to thank the members of the opposition and the leader of the third party for their thoughtful questions and the work that they've done on this piece of legislation, which I think is good legislation, proper, necessary, and overdue. Thank you very much.
Thank you. We'll just ask staff to step out and we'll carry on with the vote. Is it the pleasure of the committee that Bill number 20, Supported Decision-Making and Representation Act, stand as reported, stand as presented, and then I report the bill agreed to. All those in favor, please say yea. Yea. Against, nay. Carried. We'll take a brief recess and bring in the next department. Call the meeting back to order. Is it the pleasure of the committee to take into consideration Bill number 11, an act respecting health and safety of fishers? All those in favor, please say yea. Against, nay. Carried. Minister, would you like to have a few opening remarks and introduce?
Thank you, Mr. Chair. We get staff here from both Pedal and WorkSafe today. I've had some preliminary comments both on first and second reading. I look forward to some of the discussion around this particular bill here this morning. As I said before, this is long overdue. This is about modernizing WorkSafe legislation to treat a fishing vessel as a place of employment, and also to require personal flotation devices on those in those places of work. That's what this legislation is for. In my view, it should have happened a long time ago. We're the last jurisdiction in the country, is my understanding, to get up to speed on this legislation, and I look forward to its passage, but I also look forward to any questions that the members opposite may have this morning.
Thank you very much, Minister. Member from Shakopee-Shiloh.
Thank you very much, Mr. Chair. Welcome, everyone. We'll dive right in. Seeing as the waters are federal jurisdiction, just wondering why the province is the one. Why is it the province? Why is it them being asked to put this in place? Why isn't Transport Canada actually, the one actually carrying this and enforcing life jackets on boats?
Mr. Chairman, to the member opposite, basically there are two different lanes, so to speak. I mean, Transport Canada would deal with the integrity of the fishing vessel and the safety of the fishing vessel, but in terms of workplace safety, that would fall under the jurisdiction of WorkSafe, so that's the distinction there.
Thank you very much. No, that I understand. Was the objective of the bill was to recognize the boat as a workplace, or the objective was to have crew members wear, life jackets, while they're doing their duties as fishermen?
Both.
Thank you very much. Okay, so then the next question is, seeing as the boats will now be recognized as an official workplace, are the captains of the boat or the owners of the business, will they be asked to contribute to the cotisation de WorkSafe, so the payments for WorkSafe?
Mr. Chairman, to the member opposite, I mean, the two are two very distinct issues. I mean, in terms of compensation versus health and safety. And in the case of benefits and workers' comp, no, it's been long established in the legislation that any vessel that's got 25 fishers and under would not be required to pay into workers' comp, although if they want to, they can voluntarily pay in if they choose to. But the legislation does exempt them from 25 and under. But that's the compensation issue is a completely separate issue from the occupational health and safety issue that we're dealing with in this legislation.
Thank you very much. So you're saying that they won't, so all these fishing vessels won't have to pay in to workers' comp? Are there any other examples where workers' comp kind of impose rules and regulations but don't require that they pay into the fund?
No, there are really no other examples. I mean, I think it's safe to say that fishing would be unique in that regard. That's historically been the case. You know, I guess that conversation, I would say, would be for another day. I mean, right now, we're trying to make sure, as I've said before on the floor of this House, you know, I take my responsibility as Minister of Labour in conjunction with WorkSafe as seriously as anything I do in my role, in making sure that every New Brunswicker that goes to work every day has the ability to return safely when they're done. And ultimately, that's what we're trying to deal with here. The compensation issue, I would say, would be a conversation for another day. But to answer your question, the issue of any other industry, no, this would be the only one.
Thank you very much, Minister. Nobody's questioning, you know, the fact that, you know, we're asking fishers to wear life jackets. I think it's the right thing to do, and most of them agree that it's, you know, I think some of them already do it anyways. And you know, it'll just make the job a lot safer. I think my question is just concerning WorkSafe. So the fishers won't have to pay into the workers' comp, but what other rules, like seeing as it's now going to be recognized as a workplace, are there any other rules or regulations that workplace have? You know, will they impose other regulations other than the life preserver onto these boats?
The answer is yes, they would be treated like, as I said earlier, any other workplace. So any other workplace where you have to establish an occupational health and safety plan for that place of employment. And that, I guess, would be why we've got an effective date a little bit further out, June 2024, June 20, and allow the industry some time to develop that and get that established. We don't expect everybody on January 1st to be, of this coming year, to get all that in place. That's why we're actually giving a little bit more time in legislation for the the time that it actually takes effect is just for that specific reason. But yes, they will be treated like any other place of employment, and there'll have to be an occupational health and safety plan established.
Thank you very much. So just so the timeline for the life preservers, like the life jackets, when do you want that to be in effect?
That would be the very same time, June 2024.
Okay, so you're passing the bill today, but it only comes into effect June 2024? Is that correct?
Yes, that's correct. And like I said, just to establish, there's been extensive consultation with the industry. I think folks at WorkSafe would say it was one of the most extensive consultations they ever had with an industry, quite frankly. And there's been some concern that they just needed time to get established, and that's what that 18-month roughly time frame would allow us to do.
So from what I hear, Transport Canada is also working on a guide on regulations around fishing vessels. So what's going to take precedent? Is it going to be the rules and regulations, you know, like WorkSafe is going to impose on these fishing vessels, or is it the regulations from Transport Canada? How is that going to work out, or how are you guys going to work with that?
I think it's safe to say that WorkSafe and Transport Canada are very much in concert with one another here. They actually write us almost every year, I believe, to ask us when we're going to get on with developing this. And so, and I'll go back to my point earlier. There's two very specific lanes. There's the integrity and safety of the vessel, and there's the occupational health and safety piece. And they're two very specific lanes, but the conversation between the two of us is constant. And like I say, I think we'd use the term almost watch list, like they want to know when we're coming up with this. So great lengths will be taken through that to make sure that there's no duplication, there's no contradiction in terms of what they're doing and versus what we're doing. I think, and I would also argue, if we're one of the last jurisdictions to do it, there's some best practices that should make this a whole lot smoother and easier to establish.
So I had a chance to speak with industry, and that's probably their main concern, is that these lanes, as you call them, will overlap. Obviously, you know, the Transportation Board, they're going to come out with, you know, recommendations or requirements when it comes to safety equipment on the boats and, you know, just general equipment that they're, you know, that's being used for fishing. So I guess I just want to make sure that WorkSafe's not going to come behind and say, well, okay, listen, put those aside and we got our own set of rules, and then there's contradiction, and then, you know, if something happens, like, you know, who does what in those situations. So I'm just wondering if you could just reassure industry, saying, listen, we're going to work with the Transportation Board and we're going to, you know, make sure that everybody's on the same page.
Yeah, no, look, I think you have the department's commitment and you have WorkSafe's commitment that the consultation doesn't end. The consultation will be ongoing. I think the industry has a valid concern there. Nobody wants to see contradictions or duplications. And no, you have our commitment. We'll do that going forward. And more importantly, I think, and I can't overstate this, we just need to get on with this and make sure that we have a safe work environment for the fishers here in our province.
Thank you very much, Minister. Just wondering if you can give me maybe another example other than the life jackets of the occupational safety plan, like what other things could come up or requirements, you know, from the fishers when they have to put something in place by 2024?
So, and I'll say the same thing I said a few minutes ago. I mean, like any other workplace, we want to make sure that it's free and clear of any potential hazards that could arise. I mean, there's hoisting devices on fishing vessels. Chemicals are used from time to time. I mean, those would be two examples that immediately come to mind. But there's also a checklist that WorkSafe has already provided to industry in terms of what we would be looking for. So just anything, I would basically say, in as simple layman's terms as I possibly can, I mean, simply any hazard. You want to make sure that things are free and clear of the possibility to trip or to fall or something hits you or whatever. Like that would be the type of thing that they would be looking at, just like you would in any other workplace.
So, you know, a lot of these fishermen, they've, you know, especially the older ones who've been doing, you know, doing their trade for a long time, they're kind of set in their ways. Is there kind of like an educational piece to it, or will there be like assistance to say, okay, listen, we're going to help these fishermen kind of get on board or kind of go through the checklist?
Absolutely, and it'll be a collaborative approach, and all the more reason why we need that 18-month window so that we're educating people as we go along, as we get ready and prepare for the implementation of the start date.
Thank you, but is there a concrete, like, more like a concrete example of how you're going to assist these fishermen? Like, is there going to be like an agent say, okay, listen, we're going to put someone in WorkSafe responsible to maybe reach out to every one of these fishermen, make sure, or is it everybody on their own where they have to supply it, and if there's issues, then we'll call them?
I think the first thing that I would say is, like any other aspect of what WorkSafe does, it's not just simply a matter of passing legislation and being done with it. There's a constant awareness that needs to continually be done on a regular basis. So to that point, there will be a specific ad campaign, awareness campaign specific to this issue to start with. There will be a continuing effort to meet with the associations as this starts to roll out. I mean, one of the examples that I can give you, I know WorkSafe was at trade shows, I think the last 3 years, where fishing vessels were, trade shows for fishing vessels. WorkSafe had an exhibit at those trade shows leading up to this. So there's been a lot of that awareness on a regular basis already done. There will continue to be. To your point about will anybody be assigned, yes, there will be specific people designed or designated in each region. It won't be their sole job, but one of their jobs that will be added to the list will be to make sure that they're out dealing with both education and later on compliance. So, but I want to stress the importance of the continuous education, as we would with anything we do with WorkSafe, to try and change the culture to make people more aware of what they have to do. So as I've said numerous times today and numerous times before in the floor of the legislature, it's so that every New Brunswicker in a work environment has the opportunity to come home from their job safe. And that will be ongoing, and we realize that this is a change of culture. And that's going to take some concerted effort, not just to design the legislation and put it in place, but in terms of the awareness, in terms of the consultation and continuing to be out in front of people, and then as we move forward, the enforcement as well.
Thank you, Minister. I just want to make sure the resources are there to, help, these fishermen understand what is required from them, and also if they do have any questions or anything, when it comes time to actually, send in their plan, that they've got all the boxes checked and all that kind of stuff. But I know WorkSafe does a really good job, so I'll just take it as they're on it. You talked about enforcement. I've only got a couple of questions left. So enforcement. So when it comes to life jackets, who will be responsible for the enforcement piece?
So, Mr. Chair, to the member opposite, first and foremost, it's an enforcement officer's responsibility to make sure that compliance is there. They will have the ability to board a fishing vessel, just like they can with they can enter any other workplace environment. And but I think it's important to stress that through the awareness and through the education, we need to drive home that it's everybody's responsibility. It's the captain of the boat, it's the workers themselves, and it's the work-safe enforcement officers to make sure that we're creating a culture where everybody knows it's their responsibility to create a safe work environment. So that being said, WorkSafe has assured me that the resources are available, that we have the appropriate compliance officers in place, and on that note, I'm confident of that. But once again, that educational piece, that awareness piece, is going to be so important as we move forward, so that we continue to change that culture in a positive way.
Thank you, Minister. Again, I'm not questioning the bill. I'm not questioning the fact that we want to bring life preservers on boats. It's a good thing. Just kind of curious about the enforcement piece. So I can't imagine WorkSafe is going to, start buying boats to actually, patrol the sea just to make sure that the workplace is complying with the regulations in place. So I guess it was just a question. I imagine the enforcers will probably be on the wharf, just to making sure that when the boats come in, that the compliance is being followed.
Yeah, Mr. Chairman, through you, yeah, absolutely. I mean, there'll certainly be a presence on the wharves. But at the end of the day, if we need to work with Transport Canada or partner with others so that there can be a presence out on the water, we were actually discussing this earlier, and that certainly any and all options are out there in terms of our ability to make sure that there's compliance and that we have a safe environment.
Thank you very much. If something were to happen, God forbid it doesn't happen, but if something were to happen on the fishing vessel, how is it the captain or the owner of the boat that's responsible? Like, how's WorkSafe going to deal with an issue if something serious were to happen out to sea?
Mr. Chairman, I think the best way, and I can't stress this enough. I've said this several times today. I'll say it again. The attempt here is to treat this like any other workplace. And at the end of the day, if there's an incident, there's going to be a WorkSafe investigation like there is in any other case. It could be the captain that was involved. It could be the worker. It could be the supervisor on the boat. It could be a combination of all of those things. But that would be determined through the investigation, and from there, WorkSafe would determine whether or not there needs to be an order issued or there needs to be charges laid. But that would be everybody on that boat, as I said a minute ago, like any other workplace, has an obligation to make sure that it's a safe work environment, and the investigation will determine what's appropriate in terms of an order or charges to be laid.
Thank you very much, Minister. Yeah, it's pretty clear. I just wanted to hear that there was going to be an investigation opened up by WorkSafe. a lot of these fishing vessels, obviously, they're New Brunswick owned. They're docked at a New Brunswick wharf, but they fish in maybe waters, alongside Nova Scotia, PI, and I think you know where I'm going with this. What would happen if the incident were to occur in someone else's waters? Does WorkSafe still have jurisdiction on that boat, or would Nova Scotia have to get involved also?
I thank the member opposite for the question, because it actually drives home the reason why we need to do this and get harmonization with other jurisdictions so that we're all on the same page. And I think that's the most important thing. All the jurisdictions around us have this type of protection in place. And in terms of, if you move from one water to the other, I think it's safe to say that wherever the boat was registered out of, that would be the lead WorkSafe, where that WorkSafe investigation would be led out of, but there would be a consultation and a joint effort with other jurisdictions when that happens. So there would be certainly a partnership. If there was anything, they would be, like, let's say it's a Bay of Fundy, a boat comes off from our side and moves into Nova Scotia waters, there would certainly be a conversation between our WorkSafe and their workplace safety organization to make sure that the investigation is somewhat harmonized, I guess, for lack of a better way of putting it.
Thank you very much. Thank you for that answer, Minister. So I know Nova Scotia has had that regulation in place since, I think, 2002 for a long time. Are they also going through WorkSafe? Like, is WorkSafe the one mandating the life jackets on the fishing vessels?
Mr. Chairman, I learn things every day too, and I'm not the minister responsible for the regulatory framework in Nova Scotia. So what I would say to that is that in Nova Scotia, their equivalent of WorkSafe, the occupational health and safety component, is not with the same organization as their compensation. It's actually in the Department of Labor. But what I can tell you is that the legislation that would be with WorkSafe here in New Brunswick would be in sync with the legislation the Department of Labor has in Nova Scotia, if that makes any sense. So like I said a few minutes ago, it would be the two occupational health and safety organizations in both jurisdictions that would work together.
Thank you very much, Minister. It's just the occupational safety plan that is a concern for me, because it's such a unique workplace, the fishing vessel. So I think the consultation part is so important with the different associations, because you can't take a regular workplace in New Brunswick and say, okay, well, we're going to use some of these regulations and kind of impose that on boats, because it just won't jive. Some of the things are just impossible. Like even when it comes to dealing with chemicals on a boat, obviously there's no area where you could have closed storage or stuff like that. You know, it's more complicated when it, you know, so I just hope there is consultation. So my question was, if Nova Scotia has had this in place since 2002, have they been requiring also the fishing boats to submit an occupational plan, or is it just the piece on the life jackets that they put in place in 2002, and that's all that's required from the fishing vessels?
Yeah, no, it's very similar to ours, and it's all inclusive.
One of my last questions, when it comes to jurisdiction, so Nova Scotia has this in place. I think Newfoundland does too. PEI doesn't, and neither do we. Up north, I know we talked about the Bay of Fundy for the southern fishermen, but up north, obviously, there's a lot of fishers that go to the Bay of Gaspé, and so they're probably in Quebec territory. Does that province also have some similar regulation in place?
So in terms of the Northumberland Strait and the Bay of Chaleur, both Quebec and Prince Edward Island have the very same structure as us in terms of their compensation and their occupational health and safety being together. They both require life jackets. We're working with them continuously. We want to get a better understanding of their enforcement and how much capacity they have from an enforcement perspective. That would be the one thing that we need to continue to work with them on. But other than that, very similar to us, and it should be fairly harmonized as we move forward.
So that's all the questions I've got. I'm just going to finish with a comment. So it is a work in progress. I think there's still some details to be kind of worked out. The intention of the bill is good, again, is to bring, life jackets to the fishing vessel work area, which is not a bad thing. I'm just going to, one last comment, I'm going to say it in French, so for those who are listening. Donc, je veux juste m'assurer que WorkSafe, ou le travail sécuritaire, prend en considération le rapport que Transport Canada va soumettre prochainement sur les nouveaux règlements concernant les bateaux de pêche. Je ne voudrais pas voir les capitaines de bateaux, mettons, imposer la tâche de fournir un plan de sécurité quand déjà ils sont obligés de suivre des normes de sécurité qui ont été déjà établies par Transport Canada. Là, c'est un dédoublement de travail. Donc, j'espère que Travail sécuritaire NB va prendre en considération ce qui va être déposé prochainement, puis qu'ils vont dire, regarde, vu que c'est déjà exigé par Transport Canada, ben nous, dans le fond, on ne va pas l'inclure dans notre plan de sécurité. Part de ça, tout est beau. Un gros merci.
Any other questions? Member from Fredericton South.
Just really quickly, I just want to respond to the member opposite and assure him that this will be an ongoing consultation. It does drive home why we need that 18-month window so that we, I'll say it again, make sure that we have a safe work environment, but that we do it right, and that everybody's on the same page and that we're all rowing in the same direction. So that's been the intent all along, and you certainly have WorkSafe's commitment, and you have my commitment that I'll continue to work with WorkSafe on this as we move forward.
Thank you very much, Minister. Member from Fredericton South.
Thank you, Mr. Chair. Good morning to the Minister, Petal, and staff. Just with respect to consultation, can the Minister confirm that he consulted with the Fundy North Fishermen's Association and the Grand Manan Fishermen's Association for Bay of Fundy fishermen?
Yes, they were consulted by WorkSafe consulted both those organizations and in person.
And in the same vein, were consultations done with l'Association des pêcheurs professionnels crabiers acadiens et l'Association des cravatiers acadiens du Golfe, and thirdly, the Maritime Fishermen's Union?
Thank you, Mr. Chair. I kind of figured where the member opposite might be going. Maybe I was presumptuous in that, but I just wanted to get a list of organizations that we did consult in the fishing sector. Obviously, we reached out to our own Department of Agriculture, Aquaculture and Fisheries, Grand Manan Fishers Association, Fundy North Fishermen's Association, Fundy Weir Fishermen's Association. We met with the Regional Acadian Professional Fishers Association, the Maritime Fishers Union, Alma Fishermen's Association, Connors Brothers, and KCR Fisheries, Atlantic Canada Fish Farmers Association, the Northeast Crab Incorporated, the Acadian Association of Crab Fishermen, the Acadian Shrimp Association. So that's an example of that. That's a list of all the fishing organizations that were consulted through this. I just wanted to give you a full list there. And now, not all of that was in person. I believe some of it was through technology and other means, but there was certainly a reach out to all these organizations.
With respect to the last, well, two of the associations, l'Association de pêcheurs professionnels crabiers acadiens, l'Association des cravetiers acadiens du Golfe, are members of the federation you mentioned. So it sounds like you reached out to the federation rather than the individual member organizations of the federation on the peninsula. Were there in-person meetings with the fishermen's organizations or the federation on the peninsula, or in Fredericton if they came here? Similarly, were there in-person meetings with representatives of the Maritime Fishermen's Union?
So to the member opposite, there was a town hall meeting in Shippagan at one point. MFU was there, FRAP was there. There were a number of other member groups there. We'd have to actually go back. There should be a record somewhere of who was in the room at that particular consultation. But certainly it was widely communicated, and WorkSafe was on the ground on the peninsula in Shippagan to meet with industry. But if you want a further breakdown beyond that, who was in the room that night, we'd have to go back and get that. But there certainly was a very open public meeting with these organizations.
Thank you, Mr. Minister, through the chair. So one of the key things here is, and I think source of anxiety for some captains, is the implications of legally designating a boat as a workplace. So, you know, captains take great pride in their vessels, take great care in how they run them and operate them and equip them. So, to ensure compliance of a well-meaning bill to achieve its goals, the actual details of what the requirements will be need to make common sense. We need to make good sense. So if they don't seem sensible, you're going to get low compliance. So can the minister go through the checklist that he says has been distributed to the fishermen's organizations that would give us a sense of what actually is going to have to go into the occupational health and safety plans that the captains, I assume the captains will have to produce. In our fishery, most of our fisheries in New Brunswick, it's dominated by owner-operators. In other words, captains owning their own boats. There's not separate owners sometimes, but mostly it's owner-operators, mostly. So those captains are the ones who are going to have to create these occupational health and safety plans. So what exactly are they going to be expected to include? What's on the checklist?
Thank you, Mr. Chair. Mr. Chair, there is a checklist. It's been developed in consultation with industry to date. I'm going through it. It's a one-pager. It's on our it's on the worksite website. I can read it off if the member wants me to. It'd take me 5 or 10 minutes. But I mean, basically, It's questions like, are there first aid kits well stocked and readily available? Are crew members trained in emergency first aid and CPR? You know, is head protection available and worn where hazards exist? Like this is, I can go through the whole list if you want me to, but it's established by the, in consultation with the industry. It's on the website. I think it's a pretty, and to the member opposite's comment, from what I can see, it's pretty much common sense and attainable and should happen in order to protect people in the workplace rather. But the list is there to be read if he wants to read it. I can read it if he wants me to. I don't know if that's the most effective use of our time, but.
It's on the website. You can take a look at it there. If the minister staff can provide a link, so you don't have to go chasing around for it. There's a checklist, but I guess it doesn't cover everything that might be involved in a workplace. So if you look at the regulations, if you have certain chemicals and so on in a workplace, conventional workplace, there's a provision in the regulation that says you need to provide a shower. So this is an example. So, you know, I've been on numbers of fishing vessels over the years, and there's no way on a lobster boat that you're going to be able to put a shower in. So well, everyone has a head of some sort, but a shower. So that's the kind of thing I think that fishermen I know would be quite worried about. So how does this bill address that sort of thing where technically under the regulation it would suggest that maybe you need to have a shower, but it doesn't make any sense in the context of an inshore fishing boat.
So, Mr. Chairman, if I look at chemical safety on the checklist, it says, are all products and containers properly labeled? Is the crew trained in WIMS and the proper use, storage, disposal, and emergency procedures of hazardous products? Sorry, I might need a new set of glasses here. That's what the checklist says. I mean, I don't think we want to get in. That's what the 18 months is for. I don't know that we want to get into trying to work out what that occupational health and safety plan looks like on the floor of the legislature today, but that's what will happen over the next 18 months so that we work with individuals to get that plan in place and determine what that could look like. So I guess I don't want, I go back to my point, it's not going to be like January 1st, everybody's going to be expected to have an occupational health and safety plan in place. That's why we've got the June 2024 start date in the legislation.
Member, I'm just going to interrupt you for a few moments. We're into our lunch break now, and I know some members have meetings at noon, but I'm wondering, do we need to bring the staff back again, or are we ready to vote on this? Or one more question. Quick question, quick answer. Is that okay with the committee? Let's get her done.
So what I was referring to was more not so much the checklist you're talking about now, but under the general regulation of the Occupational Health and Safety Act, you know, there are provisions for requirements for showers in workplaces under certain conditions, right? So I'm not trying to rile any fishermen up around this, and I don't want this to be taken the wrong way, but that there is that kind of thing in the regulation, and so how do we ensure that this lines up with the reality of a fishing vessel as a workplace and things that don't make sense, that make sense ashore and don't make sense offshore, don't get imposed?
Thank you, Mr. Chairman. I know we need to get moving, but I want to get the right answer here, too. Look, that being said, based on our consultations, we don't see any situation where we would require a shower, per se, on a fishing vessel. Based on the checklist that I read there, we think that's sufficient. Based on the consultations, we're talking about a very limited amount of chemical that could be involved here. But having said that, it'll be one of those things that we continue to monitor. It's one of the reasons I've said before several times today why we need that 18-month window to establish this. And, you know, talking with WorkSafe here this morning, we will also be consulting other jurisdictions in terms of what they've done in terms of best practices there as well.
Thank you, Minister. Do you have any quick closing remarks before we go to vote?
Just really quickly, Mr. Chair, I want to thank the staff at WorkSafe for being here today, for their leadership on it, and for the department as well. And just say that I've said this many times, and I will say it again. As Minister of Labour, the biggest responsibility that I have is to continue to bring in legislation and modernization efforts to make sure that every New Brunswicker that goes to work is in a safe environment and comes home safe when their job is done. And that's what this legislation is about. It's long overdue. It's time we get on with it, and it'll bring us in line with every other jurisdiction around us. Thank you, Mr. Chair.
Thank you, Minister. We'll just ask the staff to step out and we'll do our vote. I tell you.
Thank you.
Is it the pleasure of the committee that Bill number 11, an act respecting the health and safety of fishers, stand as presented, and that I report the bill as agreed to? For it, yea? Yea. Against, nay? Carried. We'll take a 1-hour recess. Call the meeting to order. Oops. Is it the pleasure of the committee to take into consideration Bill number 12, an act to amend the Employment Standards Act? For yea? Yea. Against nay? Carried. Minister, do you have any opening remarks? Introduce your staff.
Thank you, Mr. Chairman. Look, I'm very proud of this piece of legislation. I think this is a long overdue modernization. I will say what I said the day I introduced it. This is about outlawing an archaic practice of paying a stipend when people with disabilities should be entitled to minimum wage like every other citizen. And for that reason, this legislation was introduced. It has come as a result of considerable consultation with disability groups. You'll note that some of them were here in the gallery the day that we introduced the legislation, and I'm excited about passing this. I will say that the introduction of this legislation is probably one of my proudest moments as a legislator on the floor of this House. So, having said that, I look forward to the questions that members opposite may have. And I just want to move forward and get this. If we pass this, I believe this will be an historic moment in terms of the protection of rights of workers and particularly citizens with disabilities.
Thank you. Member from Tracadie-Shala.
Thank you very much, Mr. Chair. Thank you to staff for being here today. Again, a little bit like this morning's bill, obviously it's a great bill. The intention is great, and like myself and some of my colleagues said during second reading, we were actually quite surprised that the practice of not paying at least minimum salary for wages was actually quite shocking. Like, I think we were just not aware that it was actually going on in the province. So it's a good thing that we're rectifying that, or putting an end to it. I do have a couple of questions. It's mainly concerning the day centers. I don't know the exact term that you use, but let's say, for example, in my region, I call it a day center. So you have participants coming, and it's kind of like a step before actually going out to the workforce. So they're obviously they've passed through high school. They're adults. They could actually acquire some new skills, get some in a social environment, and depending on where they're at in their development, they could actually start to get ready to actually transition towards the workforce. Okay, so whatever term that you guys use, but I'll just use a day center. Now, the day centers, obviously, in order to operate, they rely on core funding. And over the years, the core funding hasn't been sufficient to be able to what's the word I'm looking for, to satisfy all their needs when it comes to operations, cost of the building, obviously electricity and all that kind of stuff. Some of the day centers, what they're doing to kind of offset the lack of core funding is sometimes they'll take little contracts with, for example, the one in my region, they do wood pickets. So you've got DTI or even like surveying companies, they'll go buy wood pickets from them, and obviously the goal is not to make a profit, but at the same time they're doing an activity in the workshop, and they're able to bring in a little bit of revenue. The participants, from my understanding, they just give them a little something just to kind of to encourage them, or just to kind of I'm looking for the right word, just to kind of share a little bit of what is coming in to the day center. That's a huge preamble, sorry about that. So my question is, would this bill make it that the day centers would have to give them a minimum salary, or pay them at least minimum wage, while doing those activities that are part of the day center?
Thank you, Mr. Chair. I think it's the best way to describe this. I think we need, within the organizations that you're referring to, we need to distinguish between that community inclusion component, which is important, and employment. And there needs to be a distinction. I think it needs to be clear that if this is an actual employment situation where there's an employee versus employer, then yes, clearly with the introduction of this legislation, it is meant that they're going to be paid at the very minimum wage. And not only that, I think this is something that's very important to note, that this also protects individuals under the Employment Standards Act. So not only is this providing minimum wage, if there's an employer-employee relationship as it's defined in this legislation, they'll be protected and have access to all of the protection of the Employment Standards Act. I think that's important. So if it's an employment situation, then clearly they need to be paid minimum wage. If it's an inclusion service or function, then let's identify it as exactly that. It's a place where individuals go for activity. Maybe they go out for the afternoon to a community event with this organization. And if it's clearly that type of function, that's separate and apart from employment. And what I would argue is that maybe on a certain day, there's a clear employer-employee relationship where they're performing a function that they should be paid for. And then maybe on the other day, it's more of a community inclusion type function of that organization. Those are two very separate and different things. And I would also argue that if they're going there for that inclusion aspect, then maybe we need to work with Working New Brunswick to define employment for some of these individuals outside that that organization where they're actually getting paid to be an employee. The other thing I would say too is, in terms of you talked about core funding. That's not lost on us, but that's separate and apart from this legislation, and separate and apart from the fact that people with disabilities need to be treated like every other citizen. So there's conversations going on right now between Working New Brunswick and Social Development about how we might be able to enhance that inclusion component, but that's separate and apart from the legislation. At the end of the day, if somebody is in an employee and employer function, like it's defined in the new legislation, then they have to at least be paid minimum wage. And ultimately, our goal is that, you know, it's not just minimum wage. As they gain experience, they're going to be earning much more than that as we move forward as well.
Thank you, Minister. I don't want anybody to think that I'm questioning the bill, or I don't think that, you know, people with disabilities don't deserve fair wage, but just questions I've got concerning the day centers, because it does seem like it's a gray area, or it's a gray zone, because like you said, how do you make that distinction of what is, you know, an inclusion activity and what is employment? So have you guys had that discussion with day centers? Do you have personnel who are actually going to study, you know, each situation and determine if it is an inclusion activity or if it is employment?
to the member opposite's point, yeah, that engagement with organizations, we have been doing, we are doing, and we will continue to do. And trying to work with them to understand, you know, the difference between the inclusion component and the employment component. And what I would say is if you know of any organization, we want to know about it, we want to work with them. But I'll give you an example. You know, I see the member opposite smiling for some reason, but if you know of any organization that isn't getting help, that needs help with this to understand how they might be able to change their business model, we have resources in Working New Brunswick where we can work with them. And I sincerely mean that. I'll give you an example of Key Industries in St. John. A number of years ago, they had a very different model than what they have today. There's 100 individuals at Key Industries that are now in an employee-employer relationship where they're working for Key Industries, and I think there's about 10 that are in an inclusion environment. And they have partnered with government a number of times over the years. And we are certainly open to working with any agency so that we can make sure that both components are developed and respected, but at the same time, if it is that employer-employee relationship where somebody's performing a function that could be performed, that if anyone else performed it, there'd be an expectation they'd be paid for it, then they should be paid for it like every other New Brunswicker. I believe the member and I are on the same page on that. But we can work with each of these individuals. If we need to, or each of these organizations, if we need to work on a different model, we will, with them, we will do that. We'll help them with business plans. We'll help them with, there's funding through Working New Brunswick where we can do this. We want this to work for everyone. And if there's any organization that feels that they don't have that direct line into us, I mean, we have, as I said at the onset of this conversation, we have been working with them. We are, and we will continue. But if there's anything that you need us to, that you need to bring to our attention, do it so that we can get a model that works for everyone.
Thank you, Mr. Chair, or Madam Chair now. You know, I was smiling because I think the minister forgets that he's in government. He's asking me for the list of the day centres here in the province where you should have them at, you know, the tip of your fingers. Obviously, the bill that you're bringing forward could have a huge impact on these day centres. And you're saying, well, we're working with them, but if you know the names of the agencies, let me know. So it's like, did you work with them? Did you actually do your due diligence and find out that if this bill applies to them, what impact will it have on them? And again, it's okay that it does apply to them. That's not the issue. If they are doing work, I 100% agree with you. The people with disabilities should get a fair wage, 100%. The issue is, if it does have an impact on them, then it's going to put them at risk to actually keep the doors open, because the core funding that they receive is not sufficient. So if I were minister, I would have did my due diligence. I would have actually talked with them, say, okay, listen, I'm bringing this bill forward. It's a great thing. What impact will it have on the day centre financially? Will this impose, will this bill force you guys to, or not force you, but to encourage you to pay fair wage when you're doing this type of activity? If so, how can we offset the costs? Are we going to have to look at the core funding again? So I come back to the minister and I ask him, did you actually have those discussions with the day centres? And was that distinction made clear of what is an inclusion activity and what is a situation where there's actually work being done in the day centre?
to the member opposite, there's 38 organizations across the province. They have an association. We have been talking about this, and we have been in consultation for 2 years. We've met with their association. We have no desire to see any doors close. None whatsoever. And I will commit that we will work with them and our organization and all those organizations and social development to find ways, if they need to change their business model, we will work with them so that nobody's door closes and everybody continues to do the same good work we're doing right now. But that funding issue is separate and apart from the fact that if there is, in fact, an employer-employee relationship, there needs to be protection under the legislation that not only do they get minimum wage, but they get all the other benefits that they should be entitled to under the Employment Standards Act, which this bill does. But in terms of all of these organizations, if there's a new model that needs to be developed that we need to work with them on, we're committed to doing that. I've been clear on that from day one. So is our department. I know our department has briefed you, there's no cookie-cutter approach to this. All 38 organizations are different. Some are big, some are small. The needs are going to be different. Whatever those needs are, we will work with them to make sure that their doors don't close. But they can't continue to do business in an environment where it's an employer-employee relationship and they're not paying minimum wage and those people are not protected under the Employment Standards Act. That can't continue, and I think you and I are in agreement on that. In terms of what we have to do to make sure those organizations continue to thrive and, more importantly, evolve, the same way that I said key industries evolved over the last number of years. That's what we want to see. And that's what we're committed to, and the member opposite has my commitment on that we will continue to work. But that whole issue is still separate and apart from the fact that there needs to be an employer-employee relationship that's established and protection under the Employment Standards Act.
Thank you very much, Madam Chair. You've been throwing that card around all day, the commitment kind of thing, that you're going to be on it and work on it. But again, I want to come back to, was due diligence, did you do your due diligence before actually tabling this bill? So you said you consulted the 38 organizations here in the province, and I'll bet you that a lot of them asked you that question. Do I fall under the employee-employer category, or do I fall under the inclusion activity category? Because again, it has an impact. How did you, at that time, made it clear what the distinction was and where they fell?
Mr. Chair, the member opposite, I said a minute ago there have been 2 years of consultation. A lot of that consultation has actually been through social development in some of these organizations and identifying very clearly what's an inclusion activity versus an employer-employee relationship. And in the event that we identify that there's an employee-employer relationship, we've been stepping in with help through Working New Brunswick to subsidize that if that needs to be the case. And we will continue to do that as we identify more going forward. That was my point. If you know of anybody that's falling through the cracks and that hasn't happened, I want to know about it. You're out in your community listening to people the same way I am. My offer was just simply, if you know of a situation where we haven't got to somebody, we need to know about it. And that will continue as we move forward. We have no desire to put any organization out of business. It's not the intention at all. But there has been extensive consultation between social development and some of these organizations, and ultimately us. And if it's the inclusion side of things, and social development tends to handle that, but if we've identified that there's, as I said a second ago, an employer-employee relationship, there are things that we can do, and sometimes it's a subsidy, not always, but sometimes it's a subsidy we can step in, or maybe we work with the individuals so that they're at that organization for their inclusion activity, but then they go somewhere else for their employee for employment. Could be down the road. But the goal here is to work with each and every one of these individuals so that they have the ability to be contributors to the workforce like every other New Brunswicker. That's ultimately the goal here. And between our department and social development, that's what we're going to do. I don't know how much clearer I can be than that.
Thank you, Madam Chair. Well, if you were a little bit clearer, I wouldn't have to ask my questions. I mean, you're contradicting yourself, Minister. You're saying that there was meaningful consultation with the 38 organizations. Now you're coming back saying, well, social development consulted some of these organizations, and then you're like all over the place when it comes to stuff like that. All I want to know is, did the department make it clear to these day centers of what is considered an inclusion activity and what is considered a situation of employee-employer, so that they know ahead of time that, okay, listen, what we're doing here falls in that category, no problem, we are going to give them a fair wage. Now, the issue that we have now is that our core funding does not permit us to be able to operate the way we do, because obviously now we've got to pay for a wage, which again, we agree on this. There's no issue there. I think all the day centers need to know is which category do they fall under, the activities that they do. Now, if I take the Tracadie one, for example, they've got a workshop. Now, in that workshop, they've got machinery, so, you know, for those who want to go and just, you know, do crafts in the workshop, that's fine. But at the same time, they say, okay, well, listen, well, let's, il y a une expression en français, l'agréable avec l'agréable à l'utile. C'est quoi l'expression? Joindre l'utile à l'agréable. Donc, en même temps, ben, ils font des piquets pour le ministère des Transports ou le secteur privé qui ont besoin des piquets. So, basically, that's the only line of questioning. That's where I'm trying to get answers from the minister, is just, was that distinction made clear? Because there's going to have impacts. And he's kind of skating around. He's going back to the importance of the bill. And we all understand the importance of the bill. And it's a great bill. And that's not what we're questioning. It's just the impact or the adjustment that these day centers are going to have to go through if they fall under the employee-employer category.
Madam Chair, yes. Between our department and social development, that has been made clear. Do we need to continue to communicate that, as I said a few minutes ago? Absolutely, and we will continue to communicate that. And if there are organizations we need to continue to work with, if their model needs to change, as I said a minute ago, those resources are there. But yes, it is our intention to clearly define, but we need legislation to clearly define the difference between the two. And that's what this is attempting to do. And yes, we are committed to working with them, as we have for the last 2 years. I think we identified about 200 people, it seems to me, that were on a stipend as opposed to actual minimum wage, where they were clearly in an employer-employee relationship. And I believe we whittled that down to about maybe 30 some. So yes, we have over the last 2 years been working with individuals and organizations to do that, and we will continue to do that. I don't know how much clearer I can be than that. And we will continue. But this is a progressive piece of legislation that is intended and will make sure that every New Brunswicker is protected in an employer-employee relationship under the Employment Standards Act and is at least entitled to minimum wage, and hopefully, as we work with them, get them into situations where they're making even more than minimum wage.
You know, it's you said the exact same thing to students, that you would continue working with them when you cut the EI Connect program. So excuse me, Minister, for not taking you to your word that you're going to continue working and the door is always going to be open.
Point of order, Madam Chair. I hope the member opposite isn't calling me a liar. And if he is, I ask him to retract that.
Trackley Shalla for the point of order.
Thank you very much. I don't believe I used that word. If the minister is on the defensive, well, that's on him. All I'm saying is that I'm comparing this situation with another situation. Now, he's getting up, huffing and puffing that they're going to consult and that they're always going to be there. And if I know people, well, I know thousands and thousands of students who are still waiting for that call from the minister. Now, let's get back to the bill on this. You did make it clear that that distinction was shared with the day centers. That's a good thing. Took us 40 minutes to get you there, but we got there. Thank you very much. Now, my question is with social development. For the day centers, where they do fall under the employer or employee-employer category, I know they're working on a financial or structure to kind of help these day centers. Did the department consult with social development to say, okay, listen, this bill is going to change how they do things, it's going to add some expenses, and again, those expenses are good. If it is an employee-employer relationship, and I can't state this enough, that the participants need to receive a fair wage. Now, the issue is that it does have an impact on the finances of the day centers. So did the department talk to social development before tabling this bill, saying, listen, this is what we're bringing forward. I know you guys are working on a financial structure. We're going to have to work together and collaborate so everything comes together just to make sure there's continuity with the services that are being offered by the day centers.
Chair, yes.
When will the financing be made available to these day centers?
Madam Chair, I've said at the onset, these are two very separate discussions. One is about core funding, and I'm okay to have that conversation with the member at any time. But there's the inclusion component and there's the employment standards component. We're discussing a bill about the protection of individuals under the Employment Standards Act, period. Yes, there has been extensive conversations over the last 2 years with social development. And yes, I can have that conversation. The member opposite and I can sit down with the Minister of Social Development and talk about what needs to happen. But I know of nothing in the last 2 years, as we've worked with some of these agencies, that's affected their core funding, based on us simply wanting to make sure that we protect workers. But if he wants to have that conversation, that's separate and apart from legislation that protects the rights of New Brunswickers. If we want to have a conversation about core funding, we can have that, but that's not what this bill does. This bill, as the member opposite has been on record numerous times today even, saying is about making sure that employees in this province, regardless of whether you have had disability or not, are entitled to all the other protections of any other New Brunswicker. That's what this is about. We want to have a conversation about core funding. I'm all in favor of it. I'm not going to sit here and tell you what that looks like. I can tell you we have resources in Working New Brunswick, resources that we have used over the last 2 years as we've worked to get some of these people into an employer-employee relationship where they're compensated appropriately for that, and we've used Working New Brunswick resources. If we have to look at other resources, then we can do that, but that does not affect what we're trying to accomplish here today.
Thank you very much, Madam Chair. I think I've made my point. Those are all my questions. I just want to kind of finish on it with a comment on, you know, the reason I was a little bit hard on the minister today was the fact that this cabinet has a history of working in silos. And a lot of time, you know, they'll bring in one bill and maybe not realize that it has an impact in another way on the proponent. And sometimes you need like a, you know, multi-pronged approach where it's like we need to, you know, make sure all the departments are aligned and, you know, they're working together and they're saying, you know what, this has this consequence, but, you know, I've got your back on this one and we're going to help. And those were the main reasons for my questions, because again, you know, the services that these day centers offer to participants in different regions of the province are excellent. It's, you know, I know the one in my region, I visit them, you know, a few times a year. It's actually a really great place. The participants love it. The parents like that their kids, you know, are able to go somewhere, socialize, you know, do activities, and, you know, even develop new skills that could help them transition over to the workforce. So I want to end on this. I want to thank Abilities New Brunswick. I know they do great work. I know they've been, you know, they've been pushing this for a while. And I actually spoke with them, and they're very happy that this is going through. And I want to thank the staff also for working on this. And I'll leave it to my colleague for other questions. Thank you very much.
I right now recognize the member from Fredericton South and leader of his party.
Thank you, Madam Chair. Good afternoon, everyone. This bill is an important bill, and it's been long awaited by many to ensure that people, despite intellectual disabilities they may have, are treated like any other worker in terms of their pay. It's fundamental, so it's good to see this bill is here. The transition is the issue. The transition for some is the issue. And so I guess what I'm interested in hearing from the minister, and I understand and this is part of what's going on here, you know, the responsibility for employment standards. This minister has the responsibility around questions of inclusion that exist over at social development. Our Day Start to Here, or Jobs Unlimited, you know, had quite a bit of a time getting the kind of time, face time, I would say, at social development last year and earlier this year. It finally came about, but you know, so there's two departments involved here, and to make this concrete, it is the case. Well, let's think about the objective. We want to make sure that those people who with intellectual disabilities who have been in a workplace, outside day centers, a workplace, that they can continue to work there for the foreseeable future through this, you know, as the system moves from stipends to minimum wage. Okay, so the minister might say, well, that's the accommodation side. But part of the accommodation would be things like short-term wage subsidies to help ease the transition for the employer, for example. Now, on the other side of it is more social development, is that, so what about the accommodation plan, you know, at the place of work, which usually has to do with, I mean, if someone's been working there for 8, 9, 10 years, the employer knows well what sort of accommodations they need, and they've been functioning that way. But once they move into the proper wage arrangement, so they're getting paid fairly like any other worker, some employers may think, well, you know, accommodation's not going to be as easy as it was before. If I'm going to be treating them like every other employer, then I'm not going to be so open to the kinds of accommodations I've had in place for that employee before. So I guess I'll start off generally anyways with the minister in terms of what sorts of tools or mechanisms could his department put in place to support that transition in the short term.
Thank you, Madam Chair. Actually, I'm going to get to some of the tools here in a minute. I do want to talk about some of the transition work that we've done, because that was the opening comment you made around transition. And when I talk about the consultation and the work that we did with a number of people over the last 2 years, and as we move that number of 200 down to just a handful at the moment. I mean, some of the examples, I mean, we had one retail example where a stipend was being paid, and we've been able to work with that retailer in anticipation that this legislation was coming, to not only get them onto a full wage, work with them to have the same schedule, and we've been able to do that by involving some of the community organizations around, working with the families and getting to that. There was one example where we identified one person on a stipend and had been for years, and you know, we worked with the employer and identified that this person should be in the union. They're making almost $30 an hour now because of that work that our department did in consultation with their employer and in anticipation that this legislation was coming. There was one individual who'd been on a stipend for years who's now an entrepreneur because of the work that we were able to do. We can, in the service sector, we'll often put job coaches in place to shadow folks. So job coaching is one of the tools that we have both in our department and some of the organizations around the province that our department funds in order to do that. There are wage subsidies that we can put in place if the situation warrants it. And we work with all of those other community agencies, employment agencies across the province that our department funds. Like I can think of many examples. It could be the Learning Exchange in St. John that our department funds that works with underrepresented people trying to get them into the workforce. So between some of those community partners that Working New Brunswick funds and folks at Working New Brunswick themselves, there's a whole number of things that we can do. Those would be some of the tools that we would have in the box to work with. And then a constant conversation, as I've tried to explain here on the floor today, that happens between ourselves and social development on a regular basis, identifying who some of their clients are and to find ways that over time they get to be more pedal clients as opposed to social development clients. Some cases there's always going to be a social development component, but how do we get them engaged, help them, help us deal with some of our labor market demands and give every New Brunswicker who wants to work an opportunity, and in this case it would be somebody with a disability that has every right to that opportunity as anyone else. So I want the member opposite to understand there has been an incredible amount of work done over the last year or two in terms of getting ready for this transition, working with individuals, working with communities, working with community partners to get to where we're at, and we're not done yet. And I will say that if there are, one of the other members took some exception to this for some reason, but if there are organizations that we need to work with a little bit more, and we need to meet with them to help them work to, it might be their business model we need to help them fix, and we can do that through some of the tools that we've put in place here, that I've talked about here. And if there are other core funding issues that we need to have conversations about, then let's have those conversations. But that should not take away from the fact that we are very sincere about making sure that every New Brunswicker is treated the same as everyone else and has access to the Employment Standards Act the way that everyone should.
Agreed. Madam Chair, to the Minister then, is there a liaison you've appointed or designated in your department for the groups to reach out to and interact with?
I guess my quick answer to that is we've got 19 Working New Brunswick offices across the province in each individual community that understands what community partners that we have, community partners that we fund that can get them in contact with people. So their first point of contact should be their Working New Brunswick office. And the tools that we have in the box right now are in large part because of the flexibility that we've been able to build into the Working New Brunswick model that's not as criteria-based as it has been in days gone by. But if the member opposite hears of anybody that reaches out to a working New Brunswick office and doesn't get help in this, I want to know about it. Our department wants to know about it so that we can go in and fix that. But that should be your first point of contact with every New Brunswicker, including people with disabilities that are looking for opportunities, working for help navigating through the challenges of the Employment Standards Act, whatever the case may be. But if anybody, I've often said that our working New Brunswick offices needs to be the MLA's greatest partner when it comes to getting people to work. And if that relationship isn't there, I encourage members to have it. Our constituency offices should be joined at the hip with some of these working New Brunswick offices. And if any members having trouble with that too, we want to know about it, because that's what they're there for. So that should be their first point of contact.
Thank you to the Minister. The Minister's sincerity here is evident about the efforts the Department has undertaken to make this transition. He indicated that there's still some identified folks that things haven't been worked out for yet. The ultimate outcome here, beyond the important goal of the bill itself, to me, is to ensure that those with intellectual disabilities don't get displaced from their workplace, where they may have been for years. Because I know the Minister knows that is such an important piece to their well-being and their sense of themselves, and to lose that would be pretty traumatic and difficult. So, and that's no argument at all against paying fairly through minimum wage for their employment, but it is an argument for making sure no one is left behind in the transition, and that's what I care about here. I'm glad to see the bill itself. I just don't want to see anyone left behind. So those are all the questions I have, Madam Chair. Thank you.
Minister?
Just the other thing I would point out to the member opposite, I talked about people reaching out to the working New Brunswick offices. But the other thing that we should be very proud of in the last year here as New Brunswickers is that all our disability organizations that were providing employment services came together and created a co-op called Avenue New Brunswick. And it's really a model that I think is being recognized across the country as really outside the box thinking. And I think, I'm very proud of the work that those organizations did to come together to find a funding model, and one where they're all working together and working. You want to talk about silos being torn down. There's the best example of it right there. So, you know, I found it frustrating the day that we announced Avenue New Brunswick that it got very little traction in the media, and I said at the time it was probably because it was so positive. But I would also encourage members to reach out to Avenue New Brunswick for some of that employment counseling too, because they can help people with disabilities get connected through this, through some of these opportunities as well. So on that note, I want to thank the member opposite for his questions.
Thank you, Minister. Is there any further questions? Seeing none, I'll ask the staff to leave and we can have a vote. Oh, yes. Okay, I'll ask someone. And Minister, while they're leaving, if you have any final closing remarks?
Thank you, Madam Chair. Look, I just want to say that this is, I still fundamentally believe that this is probably one of the most important pieces of legislation that I've ever tabled in the floor of the legislature. And, you know, I know that there have been some concerns raised around transition, and I think as I answered the member the leader of the Green Party's questions a few minutes ago, I think we've demonstrated there's been a tremendous amount of work over the last 2 years in terms of that transition, and we're very much committed to doing that as we move forward. But I think this is a very historic day, that this will move through the committee stage, hopefully, and get on to third reading and be passed into law. As I said over and over again, this is about making sure that every single New Brunswicker has the same protection under the Employment Standards Act. Thank you.
Thank you, Minister. Is it the pleasure of the committee that Bill number 12, an act to amend the Employment Standards Act, stand as presented, and that I report the bill is agreed to? All those in favor of the bill, please say yay. Yay. All those opposed say nay. Motion carried. We'll ask for a 5-minute recess to change ministers to the next bill. call the committee back to order. And I recognize the Minister from Tourism, Heritage and Culture. Okay, sorry. It is the pleasure of the committee to take into consideration Bill number 18, an act to amend the New Brunswick Museum Act. All in favor of the motion, please say yay. Yay. Opposed, say nay. Motion carried. And I will recognize the Minister from Tourism, Heritage and Culture for opening remarks.
Thank you very much, Madam Chair. I'm pleased to appear before the committee to talk about an act to amend the New Brunswick Museum Act. Accompanying me are Shannon Ferris, Assistant Deputy Minister for Heritage and Museums, and Yenna Hurley, Deputy Minister. The New Brunswick Museum is a key cultural institution in the province, Madam Chair. It has been providing service to the public for more than 180 years, and it is the longest continuing museum in Canada. The museum has an extensive and significant collection of artifacts and specimens and provides quality and engaging exhibitions and programs. A team of respected curators, researchers, conservators, activists, archivists, and collections managers from the museum provide critical guidance to ensure objects of provincial and national significance are conserved for future generations. Madam Chair, the museum's existing facilities are inadequate and are placing the current collection of rare and important cultural and natural history objects at risk. The amendments we seek will add to the mandate of the Board of the New Brunswick Museum the authority to manage the design, contracting, procuring, and construction of a new New Brunswick museum. Finding a new home in St. John for the New Brunswick Museum, Madam Chair, is an important step in having a location that will securely preserve and showcase our province's natural and cultural history. A new facility will house a modern museum into the next century. The new museum will be designed to the latest standards for the public, staff, exhibitions, and collections management. The interior spaces will be accessible to the public and flexible to allow for the space to serve the institution and community for the next century. Empowering the Board of the New Brunswick Museum to oversee the design and building of the new facilities is necessary to ensure the project finally reaches the finish line after 30 years of discussion. The proposed legislative changes will address the issues of cost and timeline by enabling the board to procure services or use new industry approaches which have documented success for large infrastructure projects. It is important to note, Madam Chair, that the board will be required to meet all fiduciary, legal, and industry standards required for federal and provincial funding and trade agreements. Madam Chair, our government wants to ensure that the New Brunswick Museum project is managed as efficiently and effectively as possible to maximize the return on every dollar of money, public money spent. By empowering the board to manage the construction project, efficiencies may be achieved in the overall construction spending, and tighter local oversight could minimize project delays. Thank you. Merci.
Thank you, Minister. Are there any questions or comments on the bill? Recognize the member from Caracat.
Merci, Madame la Présidente. Alors, merci à Madame la Ministre et merci au personnel du ministère d'être ici pour répondre à nos questions. On apprécie ça. Alors, the legislation purpose to give the board of the New Brunswick Museum the authority to manage the design, contracting, procuring, and construction of a new New Brunswick Museum. That seems to be an onerous responsibility that you are giving to the volunteer board. So why is this being done?
Thank you, Madam Chair. Well, through you. So this is a project of utmost importance, and that is certainly no secret. I don't think that's anything that anyone in this room would argue. It's been over 30 years, 44 versions of this museum. Each and every one of those projects we've understood, would not be done, could not be done without very important partnerships, without the involvement of the board. The board is responsible for the administration of the New Brunswick Museum, and they've always been a pivotal part of, clearly of the functioning of the museum. As minister, I'm responsible for the collections. We have for the past year developed the functional plan in terms of the space needed and the details needed in terms of showcasing and protecting that collection. However, with the museum board, we have had, you're absolutely, Madam Chair, this is a big project for the board. But at the same time, I think we're underestimating the board and certainly the new members that have applied to serve on this board because of the great amount of interest in this project. So, Madam Chair, this is the right place for this project to be. It does allow the board to work faster. We had a 5 to 7 year timeline, which was not satisfactory. The board is able to be more efficient. They're able to get the work done. We're hoping faster, but at the same time with a lot of with private involvement that, to be quite frank, not everyone is, not everyone wants to write checks to government. I mean, they're very much, this is a community project, and the board, this is a way to really maximize the participation of private donors, which we know is absolutely crucial in a project of this size and of this importance.
Merci, Madame la Présidente. Merci, Madame la Ministre. Évidemment qu'on ne doute pas des compétences et de l'expertise des gens qui vont se retrouver sur le conseil d'administration, mais il s'agit d'un projet quand même substantiel, d'un projet de plusieurs millions. On reviendra au coût financier plus tard, mais c'est un très gros projet et là, on donne la capacité à un conseil d'administration de construire, faire la conception. Alors, donc, vous pensez que le conseil d'administration, c'est la bonne façon de procéder pour un musée de plusieurs millions de dollars, que ce soit eux, le conseil d'administration, qui soit responsable de designer et de construire le musée?
Through you, Madam Chair, we don't certainly expect the members of the board to build the museum themselves. Certainly, in our conversations with the board, we have every reason to believe they will be hiring a project manager, and that project manager will oversee, the project, obviously, but they will have the experience, the expertise needed to design and construct the museum. We have different competencies on the board now, different expertise on the board. There was a recent call for new board members. and really the response was overwhelming. There's so much interest in this project across the province. So I've just been so, encouraged by that. And so I believe that the competencies will very much be there in terms of that board. This is a project everyone is very excited about, and I have every faith that they can see this project to the finish line.
Merci, Madame la ministre. J'aimerais savoir à la base, qui a fait cette recommandation pour que ça se déroule ainsi? Est-ce que ça vient du gouvernement ou est-ce que ça vient du conseil d'administration? Qui a fait cette recommandation que le musée se construise de cette façon?
Through you, Madam Chair. So this was a government decision to take this route. Certainly, there's been, as everyone's aware, so much conversation around this this museum project. How do we succeed this time? It's been. Again, I've said it, but sometimes I'm still just amazed by the fact that there were 44 versions of this museum on the table or in discussion over the years. And so as minister, I can certainly say that this was a project that I was immediately having conversations about past 2 years. How can we get there? We have gone back and forth all around, many, many conversations, many ways, looking at other practices across the country. And really, at the end of the day, this was, this seemed to be the answer to truly get it, to get this museum built for the people of New Brunswick. We really cannot, do nothing and be in this situation 10 years from now. It would be absolutely unacceptable and unfair, unreasonable. And so it was most certainly the government's decision to take this on. That said, to go this route. But with that said, the board has agreed to take this on. They're up for that challenge. These are our regular conversations, and I think the department has a very good relationship with the board, and we feel very good about where things stand.
Thank you. So it was a government decision that you told the board. How many seats, was the board full when you announced that decision, or how many vacancies were there at this time when you announced the decision you took?
Madam Chair, at the time, we had on our board of the New Brunswick Museum, there had been 4 vacancies that existed for about a year. We've been just conversing about how long that was, but they had been vacant for about a year. And then 4 terms expired in September, just the September past. So this is when the timeline when we would have been having these discussions.
Thank you. Could you specify how many seats there are in total and how many there was full? Comment de sièges qu'il y avait qui étaient comblés à ce moment-là et sur combien au total, s'il te plaît? Merci.
Through you, Madam Chair, there are 15 positions on the board. Just for clarity, could I ask what timeline you're wondering when there were vacancies? Like, I just want to understand the question. You're wondering, if you can tell me what period of time you're wondering about the vacancies.
Oui. Merci. En fait, j'ai 2 questions. Vous avez dit que le fait d'aller de l'avant avec cette façon de construire le musée, avec la nouvelle loi, c'était une décision du gouvernement. Vous en avez parlé au conseil d'administration. Quand vous en avez parlé au conseil d'administration, sur 15 sièges, combien il y avait de sièges qui étaient occupés et vacants à ce moment-là, quand vous leur avez annoncé votre décision?
Through you, Madam Chair. So there are 15 positions on the board, as I had mentioned. We had 4 kind of long-standing vacancies that had been there for a while. Although we had 4 due to expire, they stayed on the board, so they remained 11. So 11 of 15 seats have been in place throughout this process.
Merci beaucoup. Et donc, après ça, si je comprends bien, il y a d'autres membres, après la décision, qui sont partis, parce que maintenant, de ce qu'on a compris, il y a moins de gens encore sur le conseil d'administration. Parce que ce qu'on nous a dit, c'est qu'il y avait, je pense, qu'il restait 7 personnes sur le conseil d'administration. Donc, après la décision, il y en a d'autres qui sont partis. Est-ce que vous pouvez confirmer cela?
Most certainly, we're not aware of anyone leaving the board as a result of this decision or these conversations we're having. There were those 4 expirations coming up, And perhaps that is what the member opposite is referring to, but no resignations as a result of this.
Merci beaucoup. Et puis, présentement, en ce moment, il y a combien, qu'est-ce que l'état du conseil d'administration? Combien de sièges sont occupés et combien sont vacants en ce jour d'aujourd'hui?
Through you, Madam Chair, so 11 of 15 positions are still at work, I guess is how I can say that, because their terms, you know, the expiration, the way it does work, until someone else is put in that spot, then those 4 have remained on the board and remained active until the new board members are in place. So only those 4 vacancies of the 15 are empty seats. They would, you know, and of those 4 expirations, or those 4 set to expire, they would be required to reapply to serve on the board again. That's not a matter of them quitting. I mean, it truly is their position expires and a new person comes into that role, and those new people we anticipate, you know, in the coming weeks coming into that role. But for now, 11 of 15 people are involved.
Parfait, merci, mais je veux juste faire sûr que je comprends bien. Bon, il y a 4 sièges là qui sont vacants, mais les 11 autres doivent être réappointés quand même. C'est bien cela?
So the notice of vacancy that closed on Friday for new board members, this is actually our second round of board appointments this year. As many boards, you know, there's a rotation to ensure that the knowledge transfer happens, and just the experience from the board. So of the 15 board members, we have 4 existing vacancies, and we have 4 that expired in September that are still there. They need replaced with this new call for board members. So that would be, we need 8 new board members to fill that roster of 15.
Parfait. Donc, on peut dire que la majorité du conseil, qui est 8 sur 15, va être appointée prochainement. Donc, les nouveaux appointements vont être majoritaires sur ce conseil d'administration. Right.
For you, Madam Chair. So we cannot, we certainly can't make an assumption that the majority of the board will be new, because as I had answered in a previous question, if you are serving on the board and it expires, you do have an opportunity to reapply. And if those people reapply, that would be for people who return to the board. So really what we know for certain is the 4 vacancies that have been vacant for too long, those will be new, most certainly, 4 of the 15.
Merci, mais on s'entend que 8 sur 15, c'est une majorité que votre gouvernement pourrait appointer. Donc, qui serait majoritaire. Je veux dire, ça pourrait, c'est une éventualité, ça pourrait arriver. Pouvez-vous me dire qui sont les membres actuels du conseil d'administration, s'il vous plaît?
I apologize for the delay. I was going through email to try to get all of those names put together because we didn't come with them. We have Emmanuel Elmangian, Pierre-André Frati. I should have asked. 1 second, please. My apologies, Madam Chair. I'm going to try that again. So we have Emmanuel Almajanga. We have Pierre-André Fruitier, Ian Baird, Chief Hugh Akaji, Catherine Eddy, Catherine Hamer, Wayne Power, William Forrestal, Stephanie Peterson, Sean McCarthy, and Suzanne Colombe.
Merci beaucoup, Madame la Présidente et Madame la Ministre. Donc, je vois que le gouvernement a appointé M. Wayne Power au conseil d'administration du Musée du Nouveau-Brunswick. Est-ce que Madame la Ministre est au courant que Wayne Power travaille au bureau du Premier ministre?
Thank you, Madam Chair. So Wayne Power, I understand, is retired from the private sector, and he is working for the Energy Secretariat under NRED.
Merci beaucoup. Est-ce que M. Power a encore des liens avec des multinationales pour lesquelles il travaillait ou...
I don't have any information on that.
Merci, merci Madame la Présidente, Madame la Ministre. Mais pour revenir à M. Power, j'aimerais savoir s'il travaille encore à contrat pour le bureau du Premier ministre. À contrat.
Through you, Madam Chair, I truly have no idea if he has a contract through the Premier's office.
Merci. Parce qu'évidemment, si tel était le cas, ça serait un certain conflit d'intérêts. Avez-vous la date à laquelle vous avez appointé Wayne Power au conseil d'administration du Musée du Nouveau-Brunswick?
Through you, Madam Chair, I signed a letter to Mr. Power on November 21st.
Merci, Madame la Présidente. Does the board have a conflict of interest policy?
Does have a conflict of interest policy. We don't have it here, but they certainly do have one.
Maintenant, pourquoi tout simplement ce projet de loi n'est pas soumis à la loi sur la construction de la couronne? Quelle est la raison pour laquelle le projet n'est pas soumis à la loi sur la construction de la couronne?
Through you, Madam Speaker. So the Crown Construction Contracts Act will actually be repealed in the coming days. So that means that that act will become part of the regulations under the Procurement Act, and the New Brunswick Museum as a public body will have to adhere to the Procurement Act and trade agreements.
Okay. Now, if I understand right, the reason why you want to, you say you need this bill to receive private sector investment or donations. So, if I understand good, the museum already has a foundation. So why can't they give money now?
Thank you, Madam Chair. So there is a foundation. Absolutely, the museum has its foundation, and they've always collected donations. They will continue to. What the idea is that the New Brunswick the New Brunswick Museum Foundation will undertake a large campaign, and the donations, private donations, will be fed, to this project through the New Brunswick Museum Board. There was, a lot of conversation around this and interest of the community donors. We're again looking at projects across the country, different projects that really operated this way, because by empowering the board to build the museum, to design, construct, construct, it's really putting the project in the hands where they need to be. I think, the donation piece, the private donation piece that the member opposite mentioned isn't the only reason why this is an attractive solution. We have, under this model, time and cost we anticipate will be saved, and that is because traditionally, and again, we're watching closely what's happening with a couple of other projects in the country, but and it's I'm not in Department of Transportation and Infrastructure, but from what I understand in the simplest way is New Brunswick or government projects, department projects would see through a design, bid, build process. And what that is every step of the way, the project is, there's bids and it's built. This way, and that's anticipated to be 5 to 7 year project. This way, the board is able to hire a manager. They can, still following the Procurement Act and the trade agreements, having oversight from the department. This isn't a free-for-all, but they have ways to get to expedite the process to get it to the finish line faster than we felt we could do.
Thank you. The question was, why can't somebody that wants to give money give it to the existing foundation? Just that.
Madam Speaker, they can and they will. My hope is they're very, very generous. Thank you.
Thanks. So why change? Why is this bill needed then?
Thank you for the question. So, as I've mentioned before, time and cost is a major factor in this project, this very massive, complex project. But a museum, by its nature, is incredibly important to the community. There is a lot of interest, and I will say that business, private donors of various levels are more inclined to donate to a project led by people at the grassroots, people in their community, than they are to write a check to the government for that project. It's an issue of ownership and pride, and being a part of something that is incredibly important. So that would be the reason why we're hoping that private donations are generous to the foundation and then through the New Brunswick Museum, opposed to government of New Brunswick.
Thank you. So when you speak about like pride and what they want, are there any strings attached, or have there been discussions about amounts of money that they would give, or what's the nature of those discussions?
Through you, Madam Chair. So certainly nobody has had a conversation with me about a donation for this project or to get this museum built. I have certainly over the past year had many conversations, the department's had many conversations with private industry, private business in a way, but there's nothing definitive. There's no promise or commitment of any certain funds. We don't even have a price tag on this project. This is something that the museum board will provide or present, but that is not something we have. And, you know, again, In terms of conversations on donors, we've never, ever anticipated building the New Brunswick Museum without support of the community. So absolutely, conversations have been had. No commitments have been made to me.
And we're just going to call a 5-minute health break. Call the meeting back to order, and I recognize the Minister from Tourism, Heritage, no, sorry, the member from Carrick.
Merci, Madame la Présidente. Okay, so through you, Madam Speaker, to Minister of Tourism, Arts and Culture, Heritage and Culture, I want to come back on the appointment of Wayne Power. So you said that you appointed Wayne Power on November 21st. I'm wondering, why is it only Wayne Power that was appointed on November 21st and not the other ones? So why did the Premier ask you to appoint only him? Thanks.
Madam Chair, board appointments can happen when there's a vacancy, really at any time.
Thank you very much. So can the Minister specify when was the closing date of like the candidacy process? When did it close?
The deadline, through you, Madam Speaker, sorry, Madam Chair, was November 25th.
Thank you. So if the process, si le processus finissait le 25 novembre, pourquoi l'avoir appointé le 21?
Madam Speaker, just through you. So in terms of this, this member of the board, my letter went to him on November 21st. It was actually, I believe, probably approved the week prior. So appointments are made to boards at various times, and really it's, in my view, this was someone who put his name forward. I saw as, Cabinet saw as an asset, and so he was appointed to fill a vacancy.
Merci. Je comprends que bon, vous voulez des membres des conseils d'administration qui soient qualifiés, pertinents, mais je me demande, sur quelle base avez-vous évalué sa candidature? Est-ce que c'est sur la base qu'il travaille pour le bureau du premier ministre, ou la base qu'il a travaillé pour Irving, ou les deux?
Chairwoman? I'm just not sure what this line of questioning has to do with the bill. The minister has answered numerous answers to the questions, and I would say if the member across the way think there's any improprieties, mention it. She's in the House, and she certainly won't have to have any legal case against her. So if she has a problem with the member, say what it is. But if not, let's go on to the appropriate bill so we can get a museum in New Brunswick, a New Brunswick museum, certainly started. And yeah, let's get on with it. Or if you have a problem, spit it out.
Okay, I'll ask, remind members. Oh, okay.
On the point of order.
On the point of order.
Oui, Madame la Présidente, concernant les commentaires du député d'en face, en essayant de dire que les questions de ma collègue ne sont pas pertinentes, j'aimerais quand même vous rappeler aux députés conservateurs que l'objectif du projet de loi, c'est d'arriver avec un nouveau conseil d'administration qui va faire la construction d'un musée. Donc, c'est exactement ça qu'on veut être certain, et que ma collègue pose des questions, c'est de s'assurer que les nouveaux membres du conseil d'administration seront ceux qui seront prêts à construire un nouveau musée, mais qui n'auront pas d'influence d'ailleurs, que ce soit du bureau du premier ministre ou de compagnies privées, afin de faire la construction de ce tel projet. Donc, vous comprendrez, Madame la Présidente, que c'est extrêmement pertinent les questions que ma collègue pose et qui sont directement en lien avec le projet de loi. Qu'en plaise ou non aux députés conservateurs, ça c'est son opinion, et puis c'est peut-être sa perception, mais je peux comprendre aussi, Madame la Présidente, que le député d'en face ne veut pas qu'on parle du fait que ce candidat-là qui a été nommé avant la date de clôture des candidatures pour le conseil d'administration auront été nommés. Cette personne-là est en lien avec le bureau du premier ministre. Donc, à un moment donné, la réalité est la réalité. S'ils n'aiment pas la réalité, c'est plate, mais c'est quand même ça qui en est. Donc, je vous transmets le message, Madame la Présidente, que c'est tout à fait dans l'ordre actuellement les questions de ma collègue, et ce serait intéressant que la ministre puisse y répondre et que les autres députés puissent écouter.
I disagree with the member. It's not, this bill is not to elect a new board. The purpose of Bill 18 is to allow the New Brunswick Museum's Board of Directors to manage the design and construction of a new, appropriate, and permanent home for the New Brunswick Museum. So it has nothing to do with building a new board. It's to build a new museum.
Okay, so I'll just remind people, the members, to keep it towards the bill, and you continue asking questions, and the minister can decide whether she feels comfortable answering or if it's to the bill. So I recognize the member from Caracat to ask your question.
Merci, Madame la Présidente. Toutes mes questions sont dirigées à propos de ce projet de loi et sont dirigées à propos du processus, parce que là, le projet de loi est à propos d'un musée qu'on veut construire et on donne tout le pouvoir au conseil d'administration. Donc, pour tenir le gouvernement responsable et s'assurer que tout est fait en bien et due forme, je questionne le processus de nomination du conseil d'administration qui, apparemment, va être responsable de tout ce qui a rapport à ce projet de loi-là pour construire le musée. Alors, Madame la ministre me dit qu'ils ont appointé M. Wayne Power le 21 novembre et même que ça avait été approuvé une semaine avant. Donc, et le processus de nomination n'était pas encore fermé à ce moment-là. Donc, quand M. le député me dit que si j'ai un problème, il faut que je le dise, bien, j'ai un problème avec ça. Et je vous le dis. Pourquoi avez-vous appointé quelqu'un avant que le processus soit terminé? Et j'aimerais savoir, pour avoir plus de détails, pour être en mesure de s'assurer que ce projet de musée du Nouveau-Brunswick soit bien fait, à quelle date M. Wayne Power a-t-il donné son application?
Through you, Madam Chair. I think it's important to understand, and I'm starting to feel concerned that having a New Brunswick museum realized is maybe not as important to all people. But I will say that there are vacancies, and there were 4 existing vacancies for a long time on this board. Make no mistake, we knew that we were heading down a path where we needed to have strength on this board. And, you know, this is, as been discussed earlier, this is a lot to ask. I don't regret asking it, and I think the board is up for it. I'm proud of the board for the way they have embraced it. I'm enjoying the fact that they're, you know, I'm hearing them on the radio, and they're up for this challenge. This is an incredibly important institution to the people of New Brunswick, across New Brunswick. And yes, absolutely, we want to have a diverse board from all parts of the province. And with the members opposite, we've sent that, we sent, you know, the posting out looking for board members. But the strength of this board is incredibly important, and finding competencies on this board is incredibly important. So I understand the attempts being made to discredit, you know, a certain board member, but this person has supply chain and project management experience, vast experience, and he has built many, many large facilities. That is very important for us to have as representation on this board, and I do not regret that appointment.
Merci. Merci, Madame la Présidente. Madame la Ministre, comment expliquez-vous que vous avez appointé des gens plus tôt cette année qui ont, selon nos informations, décidé d'abandonner, de quitter le conseil d'administration?
Madam Chair, I think the member opposite needs to be more specific, because I am not aware of anyone abandoning the board of directors of the New Brunswick Museum.
Merci. En fait, ma question, on pourrait peut-être la poser autrement. Avez-vous appointé d'autres membres plus tôt cette année, avant M. Power? –
Chair, we had, the last call we had for board nominees was September, and we appointed 4 people in September.
OK, juste pour qu'on clarifie tout ça, ce que les 4 membres dont vous venez de parler au mois de septembre, qui sont-ils? Juste pour mettre ça au clair une fois pour toutes. Merci.
Thank you, Madam Chair. So appointed in September were Emmanuel Almajunga, Pierre-Andre Fruitier, Francine Steves, and Suzanne Colombe.
Merci beaucoup. OK, mais là, j'essaie de comprendre parce que selon mes informations, vous auriez également appointé le 9 juin Kenneth Paul et Derek Cook. Mais dans la liste que vous m'avez donnée au début des questions, ils n'étaient pas dans la liste des personnes qui figurent présentement au conseil d'administration. Alors, est-ce que ces 2 personnes qui ont été appointées, selon mes informations, le 9 juin, ont quitté le conseil d'administration?
Thank you, Madam Chair. We had two vacancies, or two spots on the board become vacant in June. One was due to the passing of Ken Paul, and the other, Derek Cook, who moved out of province.
I am sorry, I did not get the answer. Is it possible to repeat or to say again?
Sure, Madam Speaker, Madam Chair, and I apologize if I didn't translate myself your French, but I thought I had captured that you were wondering specifically about Ken Paul and Derek Cook, and those vacancies. We opened those vacancies in June because Ken Paul passed away and Derek Cook moved out of province.
Merci, Madame la Ministre. Au niveau de tout ce qui est la gouvernance, le système de gouvernance, on sait qu'il y a un siège qui peut être donné au leader de l'opposition officielle. Ça fait que, est-ce que, j'aimerais juste simplement savoir, parce que nous, on est vraiment intéressés, qu'est-ce qui est les dates des prochaines réunions pour qu'on soit en mesure d'envoyer le chef de l'opposition officielle aux réunions du conseil d'administration?
Chair. So I thank the member opposite for teaching us something new today, because we just had a very quick review of the legislation, and indeed the the leader of the official opposition is welcome to attend the board meeting, which is happening next week. So we'll be sure that that an invitation is sent, so she is aware of or whoever is aware of that information.
Merci, thank you. Pour revenir au processus de nomination, parce que c'est important pour moi que ce soit clair, si vous avez appointé M. Wayne Power le 21 novembre, avant la date de clôture du processus de soumission, là, pourquoi, et vu qu'il y a 4 sièges vacants depuis longtemps, pourquoi n'avez-vous pas appointé d'autres gens à cette même occasion-là pour avoir un conseil d'administration complet? Parce que je sais que ce que vous voulez, c'est construire le musée le plus rapidement possible. Alors pourquoi, dans tout ce processus-là, n'appointer qu'une seule personne et pas faire les autres en même temps?
Thank you, Madam Chair. So as I talked about earlier, you know, the importance of strengthening the board, but this was a strength that was not existing on the board, and we felt that time was the essence in that the chair of the board also acknowledged that as a gap on the board, and so to me, it was important to have that person put in place, knowing that it was an area that we needed to have filled in terms of competency.
Merci. Donc, vous ne pouviez pas attendre 4 jours. Vous ne pouviez pas attendre 4 jours pour la fin du processus légitime.
Madam Chair, I just want to point out that it wasn't really just a few days, and I know that, you know, my letter was signed and sent November 21st, but the position was actually filled effective November the 15th. And we are still in that process. The deadline was on Friday. We wanted to have that competency on the board. We wanted to get the ball rolling on things because there are a lot of considerations. Time is of the essence. We do have funding to consider, both provincial and federal and others. So it was important to have that position in place, solidly in place, prior to the holiday season, and we are with nominations having closed on Friday. We are making very quick time in having conversations with the board to see, you know, what other gaps. They're very much involved in recommendations on the new board members and where they do not feel they have the skills. So this is all moving. But it's not moving. It hasn't been a few days. We still have time to, you know, the nominees came in. The deadline was on Friday. We did have a lot of interest. I'm grateful for that. And those are being processed, and we will need to make those approvals. But it's actually a period of several weeks.
Merci beaucoup. Donc, je comprends que vous l'avez appointé parce qu'il correspondait à ce que vous cherchiez. Mais vous dites aussi que vous avez eu de nombreuses autres candidatures qui, selon vous, étaient très intéressantes. Alors, est-ce que les autres candidatures correspondent ou ne correspondent pas à ce que vous recherchez?
So all of the applicants have met the criteria of the posting, and we're in the process of reviewing all of those applications.
Okay, seeing that it's 4 o'clock, we'll call the committee adjourned for the day.